Good morning. This is the Colorado Energy and Carbon Management Cumulative Impacts and Enhanced Systems and Practices Rulemaking. It's Friday, September 20th, 2024, docket number 240600145. Before we start the process of hearing additional testimony, we want to do a roll call. So, Elias, if you would like to do that.
Thank you. Commissioner Ackerman?
Here.
Commissioner Cross?
Present.
Commissioner Messner?
Here.
Commissioner Oath?
Here.
Commissioner Robbins? Commissioner Shea?
Here.
Mr. Chair, you have 5 commissioners present.
Thank you, Mr. Thomas. Chair Robbins will be here shortly. He's unfortunately delayed for just a few minutes, so I will start off the meeting as chair. And I believe the first item on the agenda today is to hear party rebuttals from Chevron. Mr. Neslin and Mr. Dan. Anyone else that needs to be elevated? Oh, Chair Robbins, you're here, so if you want to take over, feel free.
Great. Sorry for the delay. So we're moving to Chevron. Appreciate that. Let's elevate the appropriate people and we will hear from them.
Can everyone see that?
Yes.
I believe we have everyone in the panel. We are still looking for Derek Eggert. I believe we'll elevate him once he appears.
Very well. Chair Robbins, may we begin?
You may begin. The video panel is yours.
Thank you, sir. Commissioners, it's a pleasure to be with you again this morning. I'm Dave Neslin of Davis, Graham & Stubbs, appearing on behalf of Chevron USA. With me is my colleague, Randy Dan. I will address Rule 604B, CAPS, biological resources, and permit duration. Randy will address ESPs and the impact area. Patricia Meinrich, Luke McCartney, and we hope Derek Eggert of Chevron will be available to answer questions. Next slide. With respect to Rule 604B, the existing substantial equivalence standard is effective and has been employed in other federal and state laws and regulations. For example, under the Federal Food, Drug, and Cosmetic Act, deployers of medical devices can demonstrate that a new device is substantially equivalent to a legally marketed device to demonstrate compliance with the Act. And FDA has explicitly indicated that a claim of substantial equivalence does not mean that the new and predicate devices need to be identical. The Colorado Division of Oil and Public Safety uses a substantial equivalence standard, allowing a permittee to demonstrate that the manufacture, possession, and sale of explosives will be conducted in a substantially equivalent manner to that set forth in the agency's regulations. And earlier this year, the Colorado legislature passed Senate Bill 24205, which includes a substantial equivalence standard. This legislation regulates the use of high-risk artificial intelligence systems and requires developers and deployers to develop a risk management policy that is substantially equivalent to or more stringent than the standards set forth in the Artificial Intelligence Risk Management Framework published by the National Institute of Standards and Technology. And Rule 604B answers many of the questions you've been wrestling with. It authorizes you to find through an adjudicatory hearing that a proposed location will provide substantially equivalent protections for public health, safety, welfare, the environment, and wildlife resources, including disproportionately impacted communities. In adopting this rule, 30 of the Statement of Basis and Purpose that, quote, Distance is only one way to protect public health, safety, welfare, the environment, and wildlife resources. The Commission's rules achieve the required protection in a variety of ways, including but not limited to alternative location analysis, considerations of facility design, adherence to BMPs, requiring the use of specific control technologies, and permit conditions of approval, close quote. Next slide. And given the breadth of these protections, the rule authorizes you to consider any relevant information and identifies 7 specific factors for this purpose, including the director's recommendation, the best management practices, control technologies, and conditions of approval and how they avoid, minimize, and mitigate adverse impacts, the relevant local government's land use action, the alternative location analysis, any related siting and infrastructure, design practices to avoid, minimize, and mitigate impacts, and engagement with nearby residents. The broad reference to information and the 7 identified factors encompass all of the issues that other parties have raised in arguing against Rule 604b4. For example, resident consent is relevant information, and it also falls within the factor of engagement with nearby residents under Rule 604b4g. Enhanced systems and practices are likewise relevant information, and they fall within the factors of location design and practices in Rules 604b4b and f. The same is also true regarding potential noise, traffic, air, and other impacts. In fact, no one in this rulemaking has identified any issue or concern that cannot be considered under the substantially equivalent standard in Rule 604b4. Next slide. Some parties have suggested that a Rule 502 variance coupled with a hard 2,000-foot setback within DICs would be an appropriate compromise. However, requiring a variance from setbacks within 2,000 feet of RBUs and HOBUs and DICs would interject new factors into and materially alter the approval process for those OGDPs. Under the Rule 502 variance process, an operator must prove that the requested variance is necessary to avoid an undue hardship and that granting the variance will result in no net adverse impact to public health, safety, welfare, the environment, or wildlife resources. These 2 factors, undue hardship and no net adverse impacts, would create new and different standards for locations and are ill-suited to the OGDP process. Undue hardship would presumably require the operator to prove that no alternative to the proposed location exists. And this could prevent the Commission from approving locations that provide greater environmental utility than other alternatives, while still providing substantially equivalent protection for residents within 2,000 feet in a DIC. And no net adverse impact would presumably require the operator to prove that there will be no additional harm to public health, safety, welfare, the environment, or wildlife resources, which would be different from requiring that impacts be minimized through avoidance, minimization, and mitigation. This too could prevent the Commission from approving locations that have some impacts, but nevertheless provide substantially equivalent protection for nearby residents in DICs and provide greater environmental benefits overall than other locations. Assistant Attorney General Davenport yesterday identified several legal impediments to identifying the no net adverse impact for location approval purposes, which we agree with. And as Mr. Davenport recognized, it's notable that in addressing DICs earlier this year in Senate Bill 24-229, the legislature required operators to minimize adverse impacts, not to achieve a no net adverse impacts. And while Green Latino suggested that no net adverse impact standard would enable different environmental impacts and benefits to be netted out against each other, it's not clear how that would work. How could you responsibly compare impacts and benefits across media, such as traffic, wildlife, noise, lighting, and surface disturbance? This suggests a level of precision, quantification, and fungibility that doesn't exist. So relying on a variance process is not a compromise. Instead, it would effectively create a hard setback that impedes your ability to approve locations that achieve the greatest environmental utility while also providing appropriate protection for residents within 2,000 feet. The modified variance process suggested by Earthworks suffers from similar problems. As proposed by Earthworks, the modified variance process would shift the focus from protecting public health, safety, welfare, the environment, and wildlife resources to the much narrower issue of efforts that the operator takes to obtain unanimous consent, the contents of its communications with residents regarding consent, and any compensation offered to the residents in exchange for consent. Ironically, this approach would provide less protection for the public and the environment. It would also focus on residents within 2,000 feet and devote little or no attention to the broader public and the environment. That shouldn't be how siting decisions are made. And focusing narrowly on consent would grant individuals disproportionate leverage over their communities, could hurt economic opportunities for other residents, and could infringe on property rights. Next slide. Earthworks also proposed to redefine the substantial equivalence test in a manner that you previously rejected and that displaces the professional staff and consulting agencies. This approach would require you to compare the potential impacts from a proposed location to the potential impacts from a hypothetical location 2,000 feet from the residences. But on page 230 of the mission change statement of basis and purpose, you explain that you, quote, did not intend to set a standard that requires the commission to compare potential impacts of a proposed oil and gas location to an identical oil and gas location 2,000 feet from all residential building units. Such a standard may be unachievable and would elevate distance as the sole or predominant regulatory tool to protect and minimize adverse impacts. The commission intends for all its rules to set achievable standards, including Rule 604B4. The commission also does not intend to create a standard that elevates one method of protection over all other methods, close quote. This approach would also require a third-party consultant to review and opine on the issue of substantial equivalence. The ECMC staff has the ability and the responsibility to assess substantial equivalence, and they can draw on the CDPHE and CPW staffs for this purpose. We're aware of no evidence suggesting that the ECMC staff cannot continue to perform this function, and it's questionable whether the ECMC has legal authority to provide for such a review or to require the operator to pay for it, as Mr. Davenport indicated yesterday. And as I previously explained, Rule 604B4 already provides the commission with the authority to evaluate all of the factors raised by Earthworks, including air, water, odor, light, noise, and traffic impacts. With respect to the alternative that Larimer County shared yesterday, there's a lot to unpack, but Chevron generally agrees with the points made by Mr. Matthews yesterday afternoon. I want to expand on 2 points. First, the independent review component not only displaces the staff and raises legal issues, it's also a solution in search of a problem. Neither Larimer County nor any other party has provided any evidence that the staff lacks the ability to responsibly undertake this work or has failed in doing so. Second, the community benefit agreement component is problematic for multiple reasons. It's my understanding that community benefit agreements are usually done for much, much larger and much, much longer lasting and impactful projects, such as a liquefied natural gas terminal, major oil refinery. It's unclear who would represent the community and how that representative is selected. Mr. Sura suggested that it would be a group of nearby residents, but that suggests that the agreement itself would be just a bundle of consents and would be tantamount to a unanimous consent requirement. And requiring an operator to enter into a community benefits agreement would raise legal issues. The ECMC rules do not require operators to enter into other types of agreements. And if the ECMC cannot require an operator to pay for an independent expert, then how can the ECMC require the operator to enter into a community benefits agreement that may include monetary benefits? Next slide. A hard setback is not an abstract issue for Chevron. As we previously explained, creating a hard setback would be environmentally counterproductive by precluding the consolidation of facilities and the plugging of older, more environmentally impactful wells. Chevron plugs about 6 old wells for each new well that it drills in Colorado. and this allows Chevron to retire older wells and consolidate locations with next-generation facilities. These next-generation facilities, in turn, decrease greenhouse gas emissions by more than 90%, shrink surface disturbance by 95%, and reduce truck traffic and noise. This has enabled Chevron to eliminate more than 1,000 legacy wells in DICs to date. Next slide. Chevron supports the prompt reconvening of the Biological Resources Work Group to refine the definition of biological resources and develop a species list. And Chevron also supports the development of a regulatory process for these species that is patterned after the existing process for high priority habitats, as CPW and some other parties have discussed. Chevron believes that it would be premature, however, and current CPW staffing for and expertise on these issues. We believe that the regulatory requirements and additional regulatory requirements should await the completion of the work group's work and a rulemaking that it can address all of these issues together. Next slide, please. Chevron continues to believe that a cap is the right level for the cumulative impacts analysis, where the cap includes siting information, and that requiring additional analysis at the OGDP level would be duplicative and would disincentivize the use of caps. This is generally consistent with the August 2nd draft rules. We believe that much of the disagreement on this issue this week arises from a series of misunderstandings. First, almost all caps to date have included preliminary siting information. That's been the rule, not the exception. And at least one cap included OGDPs. Second, where preliminary siting is sought, Rule 314E11 requires operators to include alternative location analyses on the preliminary sites and to consult with the director on whether the cap substantially satisfies the OGDP information and plan requirements of Rules 304B and 304C. Rule 314E also imposes 4 pages of requirements for cumulative impacts information, including information on air, public health, water, wildlife, soils, public welfare, and DICs. And the Commission has previously imposed conditions of approval, requiring that after a future date has passed, the operator will review its BMPs and mitigation plans and will submit a Form 4 sundry notice identifying the outcome of that process and any proposed revisions to the BMPs and mitigation plans for review and approval by the Commission. The Commission can do the same thing for a cap if delay and changing circumstances are a concern in connection with that cap. So a cap with preliminary siting should not be subject to cumulative impacts analysis at the OGDP level. But we also acknowledge that if a cap does not include preliminary siting, then it presents different considerations, and a cumulative impacts analysis at the OGDP level may be necessary in that situation. Next slide, please. Chevron continues to agree with the staff and most other parties that Rule 311 and the permit duration issue should be deferred to a subsequent rulemaking that is preceded by appropriate stakeholder input. And we'd be happy to answer questions on this subject if it would be helpful. Now I'm going to turn the presentation over to Randy Dam.
Thank you, Dave. Good morning, Commissioners. It's a pleasure to speak with you again. Today I'm going to run through several 316C ESP issues and then turn to CDPHE's and CPW's comments on impact area. The first issue I will address is the Rule 316C ESP applicability timeline. As we indicated during our direct testimony in response to various Commissioner questions on the topic, Chevron has reconsidered its initial request to extend the applicability timelines for all ESPs in Rule 316C. Upon further review, we believe that for Chevron, the current January 1st, 2025 applicability date is workable for all of the ESPs in Rule 316C except those in subsection 4. Chevron continues to request the applicability date be extended to January 1st, 2026 for the ESPs in Rule 316C subsection 4, which are more design-related requirements that Chevron requires additional time to incorporate into its internal design and planning process. Next slide, please. Next, I'll turn to the ESP regarding use of closed-loop sandbox technology. Chevron suggests broadening this section to allow operators to use other technologies and systems that we believe are equally effective in reducing or eliminating silica dust. As currently drafted, this ESP allows use of only one particular technology, a closed-loop sandbox technology. This appears to be a reference to a particular company's technology, but the term closed loop is unclear. Chevron believes that is an effective technology and has used it in past operations, but there are also multiple other technologies out there that are equally as effective with added benefits. For example, Chevron uses another system that essentially keeps the sand consistently wet during the process, eliminating dust potential. This may not technically be a closed loop system, but again, it is equally as effective and also requires less truck traffic to implement. And again, the term closed loop is unclear, and I'm not sure the company whose technology is apparently referenced in the draft rule even refers to their own technology as closed loop. In sum, Chevron suggests broadening the language consistent with the red line on this slide to allow use of other technologies and procedures that are also effective in eliminating silica dust. The current language that limits operators to only a closed loop system used by a particular company would limit options and also potentially stifle future innovation in this area. Next slide, please. Next, I will address the additional ESPs identified in Rule 316C subsection 4A that require, for example, use of grid power. Regarding some commissioner questions that came up yesterday, I want to clarify that as currently drafted, these are mandated in DICs. The where practicable language in that section applies to facilities that are not located in DICs. Chevron understands and supports other parties' concerns, namely that these ESPs should not be mandated and that Rule 316C subsection 4 should be revised to allow for more flexibility for operators in implementing these ESPs. As you heard from APCD, Ms. Sorensen on Tuesday, these ESPs are based on BMPs that have historically been voluntary for operators, and not all are workable or available in some instances. Accordingly, the division cautioned against a one-size-fits-all approach for all operators and facilities. Although Chevron believes that many of its new next-gen facility designs can meet these requirements, there may be cases, particularly with our legacy company facilities, where certain ESPs like grid power may not be available. Accordingly, Chevron does not believe that these ESPs should be mandated and supports other parties' proposed changes to this rule that would provide operators with additional flexibility. Next slide, please. Now I want to focus on the electrification issue in particular. Over the last several years, Chevron has been working diligently to reduce emissions across our operations. And a large part of that journey has been partnering with third-party utility companies and REAs to electrify our drilling rigs and facilities. During this time, we've had many successes and are proud of these accomplishments and the impact they have on the communities in which we operate. However, these successes are also hard fought, and we've also had our fair share of missed opportunities where utility system upgrades were infeasible or not practicable within our development timeline. Chevron's concern with the proposed regulations is that electrification of our assets is a complex process, and at no point in the process are we able to fully commit or guarantee that third-party power will be reliably delivered on time at the right capacity. The flowchart presented on this slide highlights our workflow in working with third-party utility companies to secure power. Our initial upfront planning takes up to 18 months. During the same time, our permitting team is developing OGDP permit applications, working through several development strategies, and conducting alternative location assessments. Simultaneously, we work with the utility companies to assess electrification capability in the selected area. In practice, this is a highly iterative process. Oftentimes, we need to modify plans because power capacity is inadequate. Other times, we need to change our selected surface location as a result of our alternative location assessment process. With each iteration, utility companies must run rigorous capacity checks across their generation, transmission, and distribution systems to ensure feasibility. For a large part of our development area, these capacity checks are far from certain. It is not uncommon to be told power is not available or that power delivery to an area will take up to 4 years with no timeline guarantee. If we are able to select a location with a favorable capacity check, the project then moves into detailed design, planning, and execution, which can take up to 48 months. The first step of this process is detailing system design. The key challenge here is that there are limited utility company design resources working on oil and gas developments. At the utility companies we work with, it is common to have a single engineer be solely responsible for all designs supporting oil and gas development. For example, when Chevron acquired PDC Energy in 2023, we learned that the engineer supporting Chevron's roughly 50 job scopes was also responsible for the 50 projects that PDC Energy was also progressing. Despite applying for power 3 years ahead of development, these applications sit in a backlog and don't progress to design until our energization date is less than 12 months out. The next step of the process is planning, permitting, and procurement. A key challenge here is that the timeline for these planning steps can be unpredictable. We've had projects require transformers with 30-month lead times. We have had projects where standard conductor material takes weeks to source. We've had projects where city and county permitting processes have also taken months to resolve. Compounded with the fact that detailed design is often finalized just in time, these project planning hurdles become major challenges in hitting our energization targets. The last step in the process is construction. Similar to the design step, there are limited construction resources supporting these projects, and Chevron does not have the ability to control how and when work gets executed. We've had several projects where the utility companies plan to execute 2 months of construction in a 3-week period, utilizing temporary workforce and overtime to deliver on an accelerated schedule. One of our recent developments was impacted by this approach. Despite bi-weekly meetings, tracking project status over an advertised 4-month construction window, the utility company called a week before planning to inform us that the project hadn't started and would be delayed by 4 months. As you can see, every step of the electrification workflow presents challenges and complications, most of which are outside of Chevron's direct control. We have learned a lot over the years and are continuously working to improve our partnerships with the utility companies and have seen some progress in the space. Chevron has been and remains committed to our lower carbon vision. However, we continue to encounter one-off challenges and unpredictability in this space, which ultimately prevents us from being confident in committing or guaranteeing to energizing our future developments. Next slide, please. Finally, I will address CDPHE and CPW's positions on the impact area definition for water quality and wildlife issues, as well as some questions that came up yesterday from commissioners. CDPHE recommends a 2.5-mile radius for water quality related impacts. Chevron recommends the commission maintain the manageable 1-mile radius, which would be equally effective in addressing water quality related impacts. Chevron expects that any BMPs or mitigation measures that would be required to address impacts to water bodies within a mile would be the same BMPs or mitigation measures required to address water bodies further downstream. For example, the secondary containment and stormwater BMPs and mitigation measures to prevent offsite discharges would be just as protective for the downstream water bodies as they are for the connecting local or proximate water bodies within a mile. Accordingly, Chevron does not believe that a 2.5-mile impact radius would provide additional benefits. CPW suggests that the impact area include auxiliary facilities like access roads and pipelines that might extend outside the 1-mile radius. Chevron does not necessarily agree that these roads or pipelines that extend beyond the 1-mile radius would require additional analysis, and in our experience, CPW has not focused on these issues in the past. But regardless, no revisions to the current draft rules are necessary to accommodate CPW's concerns. Under the current draft rule 315B 2A(i), impacts will be analyzed within a 1-mile radius unless otherwise determined by the director at the pre-application consultation, in which CPW participates. If there are pipelines or access roads that CPW believes require analysis, that discussion can be had during the consultation process. There's no need to revise the definition of impact area to address CPW's concerns. Finally, commissioners had questions yesterday regarding whether it makes sense to start with a larger impact area, for example, 2.5 miles in the water quality context, that can then be pared back during the consultation process. We believe it makes sense to start with a manageable 1 mile radius initially, and if there are certain impacts outside of that radius that require assessment, the operator can conduct a targeted review of those impacts. This goes back to our initial testimony on this issue. If there are impacts outside the 1 mile radius that do require review, that should not equate to a blanket expansion of the impact radius that may substantially and perhaps unnecessarily expand the scope of the analysis. And with that, I'm finished and we're happy to take questions.
Great. Thank you very much for leading off this morning and providing the presentation to us. It's helpful. Commissioners, the panel is open for questions. Commissioner Oath.
Thank you, and thanks for your presentation. Just one quick question on that last point, and I think this came up a bit yesterday as well. With the scope of the impact area or evaluation area for water quality in particular, and with CDPHE's recommendation and thoughts on that, and knowing that they are an agency that will be involved in the conversation about the appropriate impact area, and then balancing that with the comments that we've heard about the importance of that being a very not getting bogged down and sort of not having, you know, the default or the impact area varying in every single application. It seems like if ECMC were to adopt an impact area that was not consistent with the sister agency's recommendation, that sister agency would just be in the position of having to advocate for that in each application, which seems like it kind of goes against that other objective. So can you speak to that a little bit?
Sure. Thank you for the question, Commissioner. And I think that's a fair point. I think our point is we can still start with a mile is you know, the presumptive radius. And if during those discussions with CDPHE on water issues, they believe it is necessary to look at additional impacts, I think our main point is that doesn't necessarily mean it has to be a blanket expansion of the radius, which would then bring in all sorts of other data points and resources that may not necessarily require additional analysis. During those discussions with the division, we could focus on targeted issues or targeted water bodies that are maybe outside that radius that do require additional analysis, and we could focus our additional analysis there as opposed to just a blanket expansion of the radius.
Okay, and sorry, just to make sure I understand, are you saying when you're saying blank, well, there could be a scenario where there were a different default radius for water quality assessment and everything else would stay something else. So let's say a default of 1 mile, but a different radius for water quality as proposed by CDPHE. That would, you know, blanket expand it to 2.5 for all reasons just for water quality. Or is that what you're saying? You're okay with that, or no, you still don't think that is appropriate?
No, we would still suggest starting with just the 1 mile radius, even for the water quality issues. And I guess my point is we shouldn't do a blanket expansion of the radius now up front in the rules just for the water quality issues. Our suggestion would be start with a more manageable 1 mile radius. And if we need to look at impacts outside that area, we can do so. And I think the other point we tried to make, and others can certainly jump in if they have additional thoughts, is that for the water quality issues in particular, we're not sure what the added radius or how that would equate to additional BMPs or on-site mitigations. In our experience, the on-site mitigations or BMPs that you're going to implement to prevent off-site discharges into local proximate water bodies, those would be, in our view, the same BMPs that would equally be as effective for water bodies further downstream. So I think we have some questions as to whether there's a a benefit to just a blanket expansion of the radius now at this point in the rules.
Well, I think theoretically it could be that there's not a water source within like 1 mile, but there is 1.5 miles. So it would bring that in terms of consideration and potential BMPs that otherwise wouldn't be applied.
And that's a great point. And I think in that case, we would say, okay, let's stick with the 1 mile and let's focus on that water body that's 1.5 miles outside, and not necessarily just, again, I keep calling it a blanket expansion, and maybe that's not the best term, but you could just do that targeted additional analysis as opposed to just expanding the radius.
If I could add to what Mr. Dan has had to say here this morning, Commissioner, that it seems to me there are a couple of other considerations as well. Your 400 series, I believe, have 600 and or 600 series rules impose operational requirements, including operational requirements to protect the hydrologic system. And those are requirements that apply, I believe, to all locations, irrespective of the distance to a particular water body. So just because there's not a water body, let's say within 500 feet or 1,000 feet or a half mile, doesn't alleviate the requirement that the operator undertake secondary containment of its site, underlayment of its site, berming, and other operational conditions and requirements. Second point I wanted to make is it seems to me that as you expand the impact area, you also pick up additional third-party developments, projects, activities, historic, current, future, which create noise in attempting to identify impacts associated with the proposed action, the proposed location, and the development of appropriate BMPs and conditions to ensure that the agency and the operator are protecting the public and the environment. So it creates the potential for more noise.
Okay, well, thanks for clarifying your position. That's helpful. Appreciate it.
Following up on that, CDPHE and Ms. Sorensen in their testimony also indicated that it would be appropriate that if the location was in a surface water supply area as defined in ECMC Rule 4.11, then the impact area should also extend 5 miles downstream to align with Rule 4.11A1. Do you have comments to that point?
I think, Commissioner, thank you for the question. I think we default to our position that in those cases, where there are impacts outside the default 1 mile area that we prefer, you can do that targeted additional review if necessary. I think our main point is the presumptive baseline, if you will, of where we start on impact area should remain at 1 mile, and on a case-by-case basis, that can be expanded. And when I say expanded, I don't mean necessarily just the radius, but the review can be expanded as necessary.
So to the 5 mile downstream, if that's necessary on a case-by-case basis?
Yes, I think if the parties and the agencies agree that on a case-by-case basis, in that particular instance, it is required for this particular downstream water body to take a look further downstream, if it's warranted, I think we would accommodate it that way.
Sorry, commissioners, I just jumped in, but I was segueing off of a point that was being made. Further questions for the panel? Commissioner Ackerman.
Thanks, Mr. Chair. Further segue on that same issue, and I appreciate Commissioner Oath kicking it off and your responses so far. And while we focused on water there, we've also heard a number of times specific to wildlife that the 1 mile impact area from the pad isn't preferable to an impact area associated with all operations. And so just as a thought exercise, wanted to throw out 2 hypotheticals for you and talk about if we were to go down one of those roads, which you'd prefer, understanding that you've made clear that your preference is a 1 mile radius from the pad. The first would be a 1 mile impact area, at least with regard to wildlife, not just from the pad, but from all operations. Or a hypothetical 2.5 mile radius from the pad, which would then presumably encompass many of the operations, if not all of the operations on a number of pads. And so what I'm trying to get at here is it preferable to start with a static number, whatever that number might be, or to kind of accept that it's going to be a relatively dynamic process on a number of occasions, particularly if you have CDPHE coming in each time and saying, no, the surface water impact area is a default of 2.5 miles, and you have wildlife folks coming in and saying the default is a certain buffer distance from all operations. Does that question make sense to you?
It does, Commissioner. Thank you. And I'll start off, and I'm sure Ms. Meinrich or Mr. Eggert may have some thoughts on how this may work in practice as well. And I don't mean to sound like a broken record here, but I think in all of those cases, it's starting with the 1 mile and again, taking it on a case-by-case basis and addressing these operational or other issues that in certain circumstances might require, again, a targeted review outside would make the most sense. And I don't know that in every case, CDPHE will come back and say, no, this needs to be a 2.5 mile radius. I would think that in most cases, if they think the 1 mile isn't sufficient, again, they would focus on certain water bodies or resources that are just outside that impact area that require this targeted review. I don't know that starting broad and potentially unnecessarily makes sense, where you can start with a more manageable radius and again expand that in a targeted fashion as necessary.
Thank you, Mr. Dan. Just pausing to see if anyone else has anything to add. I do have one further question then. I appreciate your response there. And I guess time would tell on the potential dynamic of that approach. I do think that that starting in that way would, at least speaking from a wildlife perspective, would potentially create a pretty dynamic process associated with each pad. This one's with regard to the biological resources question. Thank you for touching on that in your presentation. I really appreciate that. And I heard your preference for deferral on many of those issues, if not all of those issues, through a reconvened working group of some sort. I just wanted to get your specific thoughts on inclusion of a biological resources definition at this time in these rulemakings. You've likely heard that we've had some suggestions to significantly narrow that definition down to invertebrates and rare plants and their associated terrestrial and aquatic habitats. You did mention further definition. I think you mentioned your preference was deferring that to further discussion with the working group. I just wanted to verify if that's the case, or if you would prefer considering something like that definition in this rulemaking.
Commissioner, thank you for the question. Could I ask you a question that would help me to answer the question you've just posed? And the question I would ask is, how would that biological resources definition be used during the next year?
Yeah, that's a great question, and certainly something I pondered. And through my point of view, essentially what it would do is put us in a position where the reconvened working group would be able to work with surety and understand what they're looking to address. A significant portion of the previous working group's work was associated with working on a definition. And in the end, as you've seen through these hearings, it's been difficult to come to a definition through that process. And so I think what that would do was refocus a potential working group on the substance of the issue and how we address it, as opposed to specifically, implementing that with exception to the habitat evaluations that are in the draft regulations, and just add some more surety as to what we're looking for through that process as well.
So Commissioner, if the goal of adopting a definition at this point is at least in part to provide direction to the biological resources working group, I think the commission can do that without adopting a definition. I think the commission can, in your statement of basis and purpose, indicate that you are going to urge prompt reconvening of the biological resource working group to refine the definition, adopt a species list, and adopt a set of proposed regulatory requirements presumably associated with that species list that again would be patterned after the high priority habitat rules that have already been developed for wildlife. And in providing that direction, I think the commission could also direct that in its view, the definition should focus on rare plants and invertebrates, as opposed to some of the broader language that was in the prior working definition and the initial draft of the proposed rules. So I think we could accomplish that objective without adopting a definition at this point in time. I'm a little bit concerned, again, adopting a definition, how it gets used, until the rules that are intended to implement that definition are adopted. And I also think it might be prudent to have the Biological Resources Working Group pass on that definition and adopt a specific and more targeted definition, as you and others have suggested, rather than doing so in the kind of closing days of this rulemaking proceeding. Is that helpful?
Yeah, thanks, Mr. Neslin. I mean, it is clear to me that the commission has various paths that it could take. I do understand that. But what I'm inferring from your comments is that your preference is that it defers on that process entirely.
Yes, sir. That would be my preference.
Thank you. I appreciate that.
Further questions for the panel? We thank you very much for the presentation this morning. It is helpful to the cause.
Thank you, Commissioner.
Let's take a few minutes to get the next panel set up. Let's return at 10:55. All right, welcome back. We will continue with docket 240600145, and we now will hear the closing presentation from Oxy. You are recognized.
Great, thank you, Chair. Good morning, commissioners, staff, council, rulemaking parties, and members of the public. My name is Jamie Jost of Jost Energy Law, and I, along with my partner, Kelsey Wieselinki, represent Oxy USA Inc. in this cumulative impacts rulemaking. We would like to convey our appreciation to the commissioners, staff, CDPHE, and CPW on all aspects of this rulemaking process, and to commend the CDPHE and CPW for their informative presentations on Tuesday. Oxy is also appreciative of all rulemaking parties for their detailed presentations and positions. And in particular, we would like to thank Ms. Madhvi Chatur for her participation in this important rulemaking and for reaching out to all of the parties during the break. Oxy has engaged in discussions with certain parties in an effort to gain a better understanding of their positions on some of the larger issues addressed in this rulemaking. Specifically, Oxy would like to thank Adams County, allied local governments, and Green Latinos for engaging in thoughtful conversations on various rule language and concepts. These parties engaged with Oxy in detailed discussions in an effort to find common ground. Some conversations were more successful than others, but all were meaningful. Next slide, please. Today, Oxy will present on 4 topics. Oxy's revised Rule 316 Form 2D review process, which has been updated in substantive ways based upon party presentations and feedback from rulemaking parties, commissioner questions, and follow-up discussions during the rulemaking break. We'll also present on the Commission's inclusion and use of the CDPHE EnviroScreen score in general, and more specifically, when oil and gas locations are proposed in a disproportionately impacted community or a cumulatively impacted community, where there's a residential building unit or high occupancy building unit within 2,000 feet of the working pad surface. Oxy supports this EnviroScreen inclusion and will provide an example of how the score helps in determining meaningful outreach and additional protections for vulnerable communities. We'll also touch on Oxy's proposed red lines to certain rules that were included in the staff's August 2nd draft that we submitted to the Commission yesterday, actually Wednesday at this point, sorry. And we'll also finalize our request to this Commission before it enters into deliberations. Next slide, please. As you heard from Ms. Paranos during the Allied Local Governments testimony yesterday, Oxy engaged with the alternative local governments on the Form 2D process review. I'd like to formally thank them for the full support of the Form 2D review process and the confirmation that Oxy's Form 2D review process correctly recognized the Commission and CDPHE's jurisdiction conferred by Senate Bill 24229. I'd like to now turn the presentation over to Ms. Janessa Salgado, Oxy's Senior Air Policy Engineer, to present Oxy's updated Form 2D review process to this commission.
Thank you, Ms. Jost. Again, I'm Janessa Salgado, a Senior Air Policy Engineer with Oxy. Next slide, please. In response to the valuable commissioner questions we received last week and input from other parties, Oxy has revised its Form 2D proposal. Oxy would like to thank Allied Local Government for their support of Oxy's revised proposal 2 days ago and would respectively correct Mr. Sura's statement yesterday. Oxy's proposal acknowledges ECMC's authority to assure compliance with NOx intensity. Oxy's revised proposal would require all operators to provide information about changes in pre-production activity levels in the Form 2D, create a clear approval pathway for overcompliant operators, adjust how interim reports are incorporated into the review process, and clarify where the director will request consultation with CDPHE and clarify the ECMC's denial pathway. Next slide, please. To begin, under Oxy's updated proposal, all operators will be required to provide in the Form 2D their annual on-air intensity information, their interim report information, a narrative description of the ESPs that the operator plans to use, a narrative description of the operator's ability to not exceed its NOx intensity target, any other information to demonstrate compliance with NOx intensity, and a certification that the information provided in the Form 2D is true and accurate to the best of the operator's knowledge and belief. These 6 items are currently required under 316 B2A and D through G from the August 2nd draft. In its updated proposal, Oxy is requiring that all operators provide their interim report information in their initial Form 2D submittal to help inform the Form 2D review process in response to concerns we heard last week. In addition to requiring these 6 items, Oxy is proposing to add that all operators must provide a narrative of their anticipated level of pre-production activity for the upcoming ozone season compared to the previous 2 ozone seasons. By providing a comparison of pre-production activity levels, operators will provide forward-looking anticipated information for the upcoming ozone season and level set it relative to historic pre-production activity levels for the past 2 ozone seasons. Oxy heard the concerns about increases in pre-production activity levels potentially impacting intensity compliance, and we also heard the APCD's testimony about their or any operator's ability to project compliance. The narrative comparison balances these competing goals in a reasonable way and provides the director with easily accessible and direct information about changes in pre-production activity levels in the Form 2D to use in her review. Next slide, please. Turning to our flowchart, once the Form 2D is submitted, the director will review the Form 2D. If the operator is below their intensity target by 10% or greater per their annual on-air report and informed by their interim report, then the operator's Form 2D will be approved. This is in the workflow above the blue line, and I will refer to these operators as over-compliant operators. With the quick turnaround needed for the Form 2D review, Oxy is proposing that for these consistently over-compliant operators, the Form 2D will be approved by March 15th to allow for the director to prioritize more detailed review for operators that have not consistently over-complied with their NOx intensity target as required by the statute. Oxy is proposing that the threshold for over-compliant operators be a percentage because the intensity targets get more stringent each year, so using a percentage will allow this threshold to also change each year. Oxy heard the concern about the use of interim reports in its previous proposed Form 2D process and is using interim reports in the upper workflow to inform whether the operator is on track to overcomply for the 2nd straight year. Next, all operators that don't meet the criteria of the upper workflow as an overcompliant operator would move down to the first yellow box. As with the upper workflow, the director will review the Form 2D. Oxy heard the concern about barely compliant operators increasing their pre-production activity levels and how that could impact the operator's feature intensity compliance. So at this step, for operators that were below their intensity target, but within 10%, the director will review the newly added pre-production narrative comparison alongside the other information in the Form 2D. Oxy also heard the concern about the use of interim reports. So Oxy's updated proposed workflow provides the interim report to inform the director's review at this step. If after review, the director determines the Form 2D provides a sufficient demonstration, the Form 2D will be approved by March 15th. But if the director determines that the Form 2D does not provide a sufficient demonstration, then the operator falls into the very bottom line of this workflow. Turning to the bottom line in this workflow, operators will then be required to provide a detailed list of anticipated pre-production operations per the August 2nd draft, section 316, B2, B, and C. The director may choose to align this list of proposed pre-production operations with the emission information provided in Form 2Bs, and if after this detailed review, the director believes the operator has provided a sufficient demonstration, then the operator's Form 2D will be approved. If after the detailed review, the director determines that the operator has not provided a sufficient demonstration, then the director has determined that the operator must take additional actions. The director will then request consultation from CDPHE, and through the consultation, CDPHE could provide valuable input on potential actions the operator could take to reduce emissions. Next slide, please. The director will then make the final decision on what additional actions the operator must take based on all of the information on this slide. This includes the information submitted in the Form 2D, plus the detailed list of proposed pre-production operations and the potential input from CDPHE consultation. The director could require additional actions targeting emission reductions for both pre-production and production operations. For pre-production operations, the operator may be required to adjust their proposed operation list or add ESPs. For production operations, the operator may be required to add ESPs, shut in wells, or take any other action deemed necessary to assure compliance. Next slide, please. Turning back to the workflow, if the operator is able and willing to comply with the required actions determined by the director, then the operator's Form 2D will be approved. If the operator is unable or unwilling to comply with the required actions, then the operator's Form 2D will be denied. The operator may appeal the denial to the commission. Next slide, please. Oxy has provided a clean version of its proposed 316A language on these slides that align with the flowchart shown. In summary, Oxy requests that the commission adopt this revised Form 2D process that Oxy believes addresses the concerns we heard from our original Form 2D proposal.
Great. Thank you, Ms. Salgado. Commissioners, I'd like to turn our presentation over to Ms. Kimberly Mendoza-Cook, Director of U.S. Onshore Policy and External Affairs and a member of the Environmental Justice Action Task Force, to discuss a few environmental justice matters with the Commission.
Thank you, Ms. Jost. Next slide, please. Thank you, Ms. Jost, and commissioners, good morning. And again, my name is Kimberly Mendoza-Cook, Director of U.S. Onshore Policy and External Affairs for Oxy. I just want to take a few minutes to talk about how the Oxy team has utilized the EnviroScreen tool to help inform our planning, and how the August 2nd draft rules not only provide for additional protections, they provide the community with an additional resource of a community liaison, and they enhance the already robust community engagement plan. You've heard a thorough presentation from CDPHE, so I won't go into too much detail on the tool itself. Instead, I will focus on how we as an operator have used EnviroScreen to inform our engagement practices and development plans, and how you as commissioners can use the tool to evaluate and require community-specific protections and engagement. Before I get into that, I want to give my perspective on the 80th percentile baseline. According to CDPHE's technical document, this number represents the percentage of places in Colorado that are equal to or have a lower ranking than the selected area. For example, An EnviroScreen percentile of 80 signifies that 80% of the areas in Colorado are less likely to be affected by environmental health injustices than the area of interest, and that 20% of areas in Colorado are more likely to be affected by environmental health injustices. These are above the 80th percentile. And I just want to emphasize, according to the tool, more likely to be affected by environmental health injustices. The task force spent a great deal of time and had robust discussions on what this baseline percentile should be, with suggestions ranging from 70 to 90%, ultimately agreeing on 80%. Upon reaching this determination, the task force also recognized the need for agencies to have discretion to apply the definition to prioritize where they focus resources or apply the definition to a certain subset of areas that meet this definition. In addition, the recommendation goes on to state that after an appropriate rulemaking process, the agency identifies how it will define DI communities in specific contexts within the scope of the agency's work. This will help ensure that the agency will effectively target communities impacted by specific types of agency actions. Putting aside the intent of individual task force members and the decision by CDPHE to utilize the baseline to establish the CIC definition in its rules, I want to stress that the end result of not just the specific 80% baseline recommendation, but the other recommendations, in particular, all the recommendations related to community engagement, were focused on agencies and developers being more transparent, having meaningful engagement with the community, and enhancing protections in the state's most vulnerable communities. Your rules do that by requiring more accountability in DICs where there are people directly impacted by the proposed development. Now, how will we do that? So next slide, please, Sari. This slide is a data table for a random CIC, a census block group above the 80th percentile, that we pulled as an example of how the data can be used by an operator to focus attentions on BMPs and ESPs to address specific vulnerabilities. Using the EnviroScreen information helps to identify community-specific measures to mitigate and minimize impacts, inform best practices for engagement, and identify potential beneficial partnerships and projects. In this example, linguistic isolation has a score of 78.2. That would alert our stakeholder relations team that they will likely need to translate our notices and written materials, as well as have interpreters available when conducting door-to-door outreach and community meetings. The area is high for housing cost burden and income. These indicators can help identify community partners that provide assistance and services, such as Energy Outreach Colorado. Through this rulemaking, specific focus has been given to operations in the ozone non-attainment area during ozone season. This CIC's ozone component score may lead to further evaluation because of its high vulnerability in this community. It is also in a floodplain area. The local government will look at this and determine if additional measures need to be taken to avoid or minimize this impact, and the Commission will consider these measures in its analysis. The use of this tool gets to the root of what we've been discussing in this rulemaking. How can the Commission provide additional protections to the most vulnerable communities? By using the data to require robust development plans that focus protections to address specific vulnerabilities, hold operators accountable for meaningful engagement, and inform areas to seek community input to identify potential benefits, the Commission is not only being protective, you're recognizing that no one community has the same burdens or needs, and each should be met where they are. Next slide, please. Oxy supports 315B2DGG, but does propose minimal edits. The edits are meant to better reflect the purpose of the EnviroScreen score and clarify already submitted information to avoid duplication of the submission on this plan. Next slide, please. I'll now turn it back to Ms. Jost for the remainder of our testimony.
Wonderful. Thank you, Ms. Mendoza-Cook. I'll now take a few minutes to review Oxy's updated redline proposals to the August 2nd draft rules based on case-in-chief testimony provided by the parties, commissioner questions, and numerous discussions with other stakeholders over the course of this rulemaking break. Next slide, please. Oxy heard many ENGO and citizens groups, specifically Green Latinos, request to expand the footage or radius of an operator's outreach, information disclosure, and public comment allowances as well as the information contained in certain maps and plans when there is a proposed oil and gas location within 2,000 feet of an RBU or high occupancy building unit in a DIC or CIC. In an effort to provide expanded protections in response to these concerns, Oxy's red line proposes to expand the footage or radius from 2,000 feet to a half mile in the rules shown on this slide. This would be Rule 301H, which Oxy is referring to as the pre-application disclosure, which we'll touch on in a minute. The public comment period, certain alternative location maps, location drawings, the community outreach plan, post-completeness consultation for building unit owners and tenants, post-completeness consultation with CDPHE, the comprehensive area plan cumulative impact analysis, and then also the cumulative impact analysis that Ms. Mendoza-Cook just mentioned in her testimony. While Oxy supports the expansion of the footage and radius for informational purposes, this support is contingent upon the Commission's confirmation that this expanded footage or radius does not result in affected person status under Rule 507. Oxy does not support the expansion of these rules to 1 mile because, as you heard in Koga and API's testimony, there is a lack of scientific basis for that expansion. And further, this increase of this radius and footage by 560 feet is significant in its own right. Oxy did have communications with Green Latinos regarding the footage and radius increase. However, a resolution was not reached despite Oxy's efforts. But even Conservation Colorado proposed 2,500 feet in its case last week. And when asked about the 2,500 foot in radius by Commissioner Cross, Mr. Sura did confirm that Conservation Colorado originally supported 2,500 feet. Yet you heard yesterday that they now want 1 mile, but had no reason to support the unexplained footage. Next slide, please. Oxy's red line also proposes several other changes that we believe include certain ENGO and citizen group stakeholder requests and to otherwise serve to clarify the purpose of certain rules. These rules are 301G, with the change from pre-application consultation to pre-application meeting. Oxy proposes a change in the name only to reflect the purpose of the meeting and to better align with local government verbiage. The CDPHE did refer to this as a pre-application meeting throughout its presentation, where intensive discussions are to occur with the formal consultation upon completeness. And Oxy does agree to the use of this term. This may also assist in resolving certain concerns as to the formality of the meeting versus the formal consultation that occurs after OGDP completeness determination under the current process. With respect to Rule 301H, Oxy is proposing to change the name of this rule from pre-application notice to pre-application disclosure. The sole purpose of this is to change the term notice to disclosure to avoid confusion of the affected person's status. The use of the term notice in Rule 301H could be deemed by a recipient of that notice as granting affected person status. This is not the purpose of the pre-application disclosure, and the Commission could avoid this confusion simply by changing the term. Oxy proposes to use the term pre-application disclosure in order to avoid any confusion on behalf of recipients receiving this pre-filing information. With respect to Rule 304C19, the community outreach plan, as drafted, the August 2nd rule only applies to community outreach plans in a DIC or CIC, and Oxy believes that this may have just been a simple oversight in the drafting. Oxy proposes changes to this rule to expressly require a community outreach plan where there is a residential building unit, high occupancy building unit, child care center, or school facility within 2,000 feet of the working pad surface of a proposed oil and gas location for all OGDPs, not just those in DICs or CICs. With respect to Rule 304D, Oxy has reviewed the request from several ENGO stakeholders to confirm that no lesser impact area exemption should be granted by the director in a DIC or CIC, and Oxy agrees with those proposals. And finally, 308A2, Oxy's concerns remain with respect to the involvement of the Commission Reclamation Group at the APD filing and approval stage on existing locations. Not only would this be a fundamental change from the Form 2 APD review process that was likely not contemplated by the 2024 cumulative impacts legislation, but the denial of an APD for an outstanding reclamation issue could be punitive in nature. In many instances, reclamation issues can take years to resolve with the Commission's reclamation group, if they're even closed at all. to prevent an operator from obtaining a new APD on a location that is subject to an Oakland reclamation issue is unreasonable and unnecessary. If there are continuing reclamation issues on an existing location seeking new APDs, then the commission director and staff can rely upon the existing 1000 series reclamation rules, their own inspections, and the 500 series enforcement rules to address reclamation concerns. Next slide, please. Oxy appreciated the Allied Local Government's thoughtful presentation and proposed edits to Rule 315B2D to include the Commission's avoid, minimize, and mitigate hierarchy of protections for public health, safety, welfare, environment, and wildlife resources. Oxy has included the Allied Local Government's language for the most part in its current red line and would request that the Commission adopt these revisions. Next slide, please. This slide was included in Oxy's case-in-chief presentation, but bears repeating because these additions are modifications that would serve to clean up and clarify certain rules that are vague or ambiguous in the August 2nd draft. Again, I won't go through each of these rules, but we would request the ECMC staff as well as the commissioners review these cleanup edits in an effort to review these as they draft the final rules. And then finally, we would like to reiterate, next slide, please, Oxy's requested relief in this rulemaking. Specifically, Oxy is seeking the denial of any rulemaking party's request to reincorporate Rule 604C or any modified iteration of Rule 604C. Oxy is opposed to all of these proposals. The denial of any rulemaking party's request to have the Commission create a NOx threshold, the denial of any rulemaking party's request to reincorporate sector-wide penalties relating to NOx intensity status, and then we would request the adoption of Oxy's Rule 17 red line language that was submitted to this commission, specifically the Rule 316 Rule 2D review process language that was supported by allied local governments, COGA, as well as Civitas during their presentations yesterday. We would support an increase from 2,000 feet to a half mile in the rules cited in this presentation, so long as the extended area does not result in affected person status under Rule 507 and is informational only. We've also proposed language in our red lines for this as well. We would support the maintaining of the August 2nd draft Rule 1 mile impact area with the discretion of the director to expand that area based upon the scientific and technical expertise and input from the operator, the director, commission staff, relevant local government, proximate local government, CDPHE, CPW, and the community liaison, who are all invitees and likely attendees of the pre-application meeting on a case-by-case basis specific to the proposed development plan. And I should clean that up. Those folks are always involved. They're not invited on a case-by-case basis, but they would be reviewing a project on a case-by-case basis specific to the proposed development plan in order to determine if the scope, nature, and intensity of the project would need to have a larger impact area than the 1 mile that's currently in the rule. Oxy specifically requests deference to the CDPHE Air Pollution Control Division for its experience on NOx and GHG intensity target compliance and enforcement, its position on the lack of the need for the Commission to adopt duplicative air monitoring regulations, and the position on the difficulty in forecasting NOx emissions at this point in time, as presented by Ms. Sorensen, Ms. Fury, and Ms. Martland during their testimony yesterday. And again, we would hearken back to Oxy's new Form 2D process that takes all of these issues into account, and we believe resolves any concerns of any jurisdictional or other compliance questions. And then finally, Oxy would support a deferral of any formal adoption of a biological resources definition or other specific rules relating to biological resources, and would support the reinvigoration of the Biological Resources Working Group to address CPW, Commission, operator, and stakeholder positions and proposals that were brought forth over the course of this rulemaking as they relate to biological resources. And Oxy appreciates the Commission's review and substantial consideration of Oxy's positions and proposals when you enter into deliberations. Commissioners, with that brings us to the end of our closing presentation. And I'd like to go ahead and ask all of our subject matter experts that joined us last week to come on video for any questions you may have about our presentation today or any of our filings in this rulemaking docket. Thank you for your consideration of Oxy's positions. And sorry, we can stop the screen share. Thank you so much.
Thank you very much. I'm seeing your subject matter experts elevating themselves and visualizing themselves. We appreciate the information provided this morning. Commissioners, we have a full panel for questions. Commissioner Messner, then Commissioner Oath.
Thank you. Thank you for the presentation. Thank you for the information. Ms. Salgado, I wonder if you could bring up the flow chart again. And I wanted to just make sure that I understand how you anticipate that being applied. Appreciate the flow chart. Appreciate the continued revisions to it. I think it's a good tool for better understanding how something could apply. But in this, we've got different steps where the director may make a determination that things that an operator is proposing is a sufficient demonstration. I'm trying to better understand what are those things that an operator could propose that would be a sufficient demonstration to meet the different targets that you have lined out in there, understanding that it appears at least that some jumps are bigger than others, so would require more steps to be taken. And so maybe you could help me just give some examples of what would be things that could create sufficient demonstrations in some of these steps. Does that make sense?
Yeah, thank you for your question, Commissioner Messner. So I think what the operator will be providing is what is on the Form 2D. So that is what will inform this demonstration step. And so what our definition currently of kind of a sufficient demonstration is that it means that from the Form 2D, the ECMC has determined that additional actions aren't required. So aligning with SB 24-229, that if you make a sufficient demonstration, that means that the director does not believe that additional actions are required.
Okay, I mean, I understand that part. I guess what are the things that an operator would do in order to take the steps to create that sufficient demonstration, I guess. So you're potentially out of compliance for NOx. So you're in the let's say you're in the operator provides list of proposed pre-applications operations per 316 B2 BC. What are those list of proposed pre-production operations that would enable the director to make that sufficient determination that in fact you look like you're headed towards compliance? Does that make sense? Like what
Yes.
are those things and like what would you do to make those steps?
Yeah, if we could go back one.
Yeah.
If we go back one slide, Sabi. So right, all of this information would be included in the Form 2D. And so if the operator had not complied with intensity historically, where I see the demonstration part really coming in is the narrative of ESPs detailing what in ESPs you're going to utilize on both the pre-production and production side to minimize emissions moving forward. Any other information box to demonstrate compliance, and then also what we're adding, that pre-production narrative. I think that's really critical for if an operator didn't comply with NOx intensity historically, if they're detailing in that, we are anticipating to run half as many drill rigs or half as many completion crews, that's really the information that they could provide in that Form 2D to kind of demonstrate that additional actions aren't required. And so then going back to the box of where the operator is listing the operations by name, that's where they would be providing every well name, every site name. We're envisioning that there to allow the director to align the Form 2B emissions with that detailed list, so that the director has even more information about the scale of proposed pre-production operations for the upcoming ozone season. So sorry for not a clear answer. I think it's all of these components stacked together, that the director is reviewing, in her review.
Okay, that's helpful, at least to get my head around it. And it may be that in attempting to get that sufficient demonstration, I think as you indicated, that there may have to be some reduction in operations during a particular season, right? Or cessation of operate. I mean, like everything's on the table as far as making this determination. Is that fair to say?
Yeah, so when the director is reviewing, everything that the operator has provided is on the table. And then as far as potential actions, I agree that the director then has will request consultation with CDPHE and any potential emission reduction items identified are on the table for the operator to then be required to take after that point.
Okay.
And Commissioner Mester, if I may, Ms. Zivkovich, would you like to add just kind of one more thing about this on the table? And then I'm sorry, on the flow chart. Sorry, if we could go back to the flow chart. Ms. Zivkovich, would you like to jump in here for clarification on just the below line for a second?
Yes, thank you, Ms. Jost, and thank you for the attempt to clarify, Commissioner Messner. We did want to make clear that that top line is really over compliant operators. So anything below the line is not necessarily out of compliance with the previous year targets. It's those that are not over compliant. So it could be an operator that's just not over compliant. They met the targets and that they, based on their planned production compared to the previous 2 seasons, it is showing that they're going to stay in compliance. So really it's that first line under that first green line process, that first flow under the blue dotted line that would encompass those that are in compliance and demonstrating that they will continue to be in compliance based on planned activity.
Okay. Thanks for that. I think my only other just clarification, and I think this this proposal to expand the radius on a number of different items to a half mile, I appreciate that consideration and you thinking about this. And but I wanted to clarify. I think on the slides at least it talked about that half mile being 2,500 and some feet. And just to be clear, at least I think that a half mile is 2,640 feet. And so just wanted to make that clarification in there as far as I didn't know if those had carried over into your red lines or not. So
Yeah, and Commissioner, that I appreciate that. Yes, the intent is a half mile. If we had some numbers interposed, we can change those.
okay, great.
Yes, thank you.
Commissioner Oath?
Great, thank you. Appreciate your proposal. I have just a couple of questions on the NOx stuff as well. Really appreciate the updated proposal. And in the red line, well, I guess in both, I had initially wondered why you were no longer having operators submit in the Form 2D information about the oil and gas locations to be constructed, wells to be drilled, completed, converted to Class 2 UIC, et cetera. But I see that's the part that you're saying, if an operator is not an over compliant operator, then they submit that information. Am I understanding that right?
Yeah, could we pull that up, Sari, real fast? So it's kind of in the third level of this in the very bottom workflow. So if you're not an over compliant operator and the director's initial review of your Form 2D does not provide a sufficient demonstration, then you're providing that detailed list in this yellow box on the bottom line.
Okay. And this is kind of a small nit thing about process. Could you, just to try to make it more efficient, could you not just say, if you like, in terms of listing out the requirements of what gets submitted in a Form 2D, like if you are not more than 10% compliant with your NOx intensity target, then you also submit these things. So it's not like 2 submittals, just one document that comes in. Does that make sense? But it only applies to those who are not more than 10% compliant.
Yeah, I think we can take that back to think about.
Okay, it just seems like it would eliminate one step of back and forth between the agency and the operator.
Commissioner
just-
Oath, may I ask a follow-up on that?
Yeah.
I think I see where you're going with this. So you're looking at basically the content of the Form 2D, right? So if you have an initial 2D that you're filing, there would basically be like a separate section that might say, if you are kind of on this lower line, then you have to submit this information.
Yeah, just submit
okay.
it right up front.
Okay.
Yes.
That's helpful. That's helpful. Okay, we can chat internally on that and appreciate that, and can update a red line if we need to.
Okay, thank you.
And sorry,
And
I'll just.
then- Oh, go ahead.
Oh, I was just gonna add, for our logic of this is that we feel it's most helpful for that detailed list of operations to be provided, where the director is gonna sit and align your 2B emissions alongside that list. And so that's why we were trying to prioritize this for the smallest subset of needed operators. But yeah, we will take that back.
Okay. And then can you talk about why 10% as the cutoff there, how you came to that?
Yeah, thank you for that question, Commissioner Oath. So we definitely heard your concern specifically about quote unquote barely compliant operators being included previously in our streamlined upper workflow from our previous proposal. And so we were trying to determine a threshold that could represent like meaningful overcompliance. And so, the level, we try to figure out a level where, small changes to emissions or production levels wouldn't just lead to that level of overcompliance. And so we landed at 10% in this proposal.
Okay. But it's not based on anything in particular, more just like a judgment of like what would be like, yeah, we feel like more than 10% that is pretty confident that the operator will continue to be in compliance upcoming year.
That's correct. We thought it was, a reasonable starting point with this new program kicking off. And once we can see more data, I think we would have more information in the future.
Yeah, okay. Thank you. And then let's see, in the red line, something caught my eye in sort of later down, but it actually the language is different in your flow chart. So what caught my eye in the red line is, for these operators that are not overly compliant and they're submitting the additional information about the number of wells to be drilled and completed, etc. And the director still doesn't feel like that's a sufficient demonstration. And then there's this consultation, and then additional conditions could be imposed. And then you said, if the operator is able or willing to comply, then the director would recommend approval. And that caught my eye as kind of an unusual standard. So I would have expected something like, if the operator is, maybe just is able to and is committed to, or, you can require it, but in particularly the or there. So for example, like if an operator is willing to comply, but isn't really able to comply, that doesn't seem like it should lead to approval. But in your flow chart here, you have able and willing. So I don't know if you had a response to that piece.
Yeah, thanks for bringing that up. I think it was just a typo in our red line. It should be able and willing.
And okay. That's helpful. And then I might have missed this in your last proposal, but the appeal part seems new. So just wanted to hear if you had any additional information or thinking behind that, and, just always thinking about things that add time to the process.
Yeah, I don't recall that it was on our original flow chart, but I think our intent was always to keep this appeal to commission language consistent with what we had seen in the August 2nd draft, but I'll also let Jamie, Ms. Jost jump in.
Yeah, I'm happy to take this over, Commissioner Oath. So in the August draft rule, there was a provision, at least we believe there was a provision that basically said if there is a denial of a Form 2D, then the operator did have the ability to appeal that decision to the commission. And so we just maintain that process. I think would be helpful to include in this process for confirmation that an operator is having the appropriate due process. If it is going to be told it cannot conduct operations under an existing valid permit in ozone season. So that was part of the staff's process.
Okay, that's helpful. Thank you.
Yeah, you're welcome.
And then I do have questions. I know that this part hasn't changed since your last proposal, but I did, continuing to mull this over, I have some questions about your proposal to delete all of 316A. And I think your reasoning has been that you feel like it's duplicative. And I want to better understand your thinking on that, because the way I'm understanding it is it would not necessarily be duplicative, and in some cases could help the commission catch operators and not approve new locations that are then just going to get caught in a Form 2D and not able to drill in an upcoming season or have to take a bunch of different actions. So I guess I see that not as duplicative, but as a very different kind of consideration of whether or not the commission should approve a new location based on kind of where an operator is overall and being able to meet their intensity target.
Yeah, Commissioner Oath, I'm happy to answer this one. So we did cut 316A out in its entirety. One, because you're spot on. We do think that the information would be duplicative. You're going to have NOx and GHG intensity status information in the cumulative impacts analysis that goes in with an OGDP application. You will have already, at least maybe not you, but your director and the staff, as well as CDPHE, CPW, a laundry list of stakeholders will have already addressed NOx and GHG intensity target at the pre-application meeting. And then specifically, when we're looking at this from the timing and the allowance of an oil and gas development plan permit, that permit is valid for 3 years. And so to deny an oil and gas development plan permit, potentially on the basis of NOx intensity target specifically, 3 years before that permit would be up, really isn't giving credence to the Form 2D and emissions review for an upcoming ozone season within that 3 years. So if they're maybe not compliant or in that lesser 10% when they get their oil and gas permit, but in 2 years during the validity of that permit, they may bring themselves into compliance under the Form 2D process that Janessa just went through and in consultation with CDPHE, the commission would be foregoing potentially a location that could still be developed in compliance within that 3-year OGDP period. So you'd almost be making a premature decision and cutting short an operator's ability to develop their assets on an annual compliance basis with CDPHE. And Janessa and Angela, I'll defer to you if I kind of missed anything there, but that's really our concern, is that it's a premature decision given the 3-year permit period for an OGDP.
Sorry, just pausing to see if anybody else wanted to add as you indicated. Okay, that's helpful. And I that makes more sense to me and as a duplicative. So I appreciate that a lot. Thank you. And I think that's it.
Other questions for the panel? Commissioner Cross?
Thank you, Mr. Chair, and thank you for this. I appreciate the effort to look into some different topics on some of these, such as the Form 2D and the work with other parties on that. I want to ask about something a little different and maybe focus on some of what Ms. Mendoza-Cook talked about, specifically the use of the EnviroScreen, and try and make sure that I fully understand what you're proposing with that. The way I understood your testimony is including the EnviroScreen score as part of what's looked at for determining which BMPs will best impact and benefit, especially disproportionately impacted communities, correct?
Thank you, Commissioner Cross. I think, yes, to some extent, I think, but going further on that, what we wanted to show in walking through that was that the August 2nd draft rules, by incorporating by referencing EnviroScreen and incorporating some of those tools into the analysis that you're going to do for DICs and CICs, that it was really more of a showing, not for specific BMPs, but a showing of how the commission and the operator, through our planning process, as well as our engagement with the director through the completeness review and all of the things when submitting an OGDP, that enhances all of those plans to really take a deeper look at how you can use those numbers to incorporate specific BMPs within disproportionately impacted communities or cumulatively impacted communities. So really it was more of a showing of how that tool, that incorporation that you all put in your August 2nd draft is really able to use to show specific protections based on the community's needs.
Step beyond the evaluate and use that as a way to help the address aspect of cumulative impacts.
Yeah, and from your perspective in terms of how you're looking at it, those numbers are helpful in terms of what those stressors are on any given community. But I have Ms. Coleman and Mr. Lytle on our teams, that are in our planning process, and they use this tool already to sort of inform how we're going to do engagement and how we're going to do project planning. And so I think that we're already looking at it as a tool to help enhance our OGDPs that we're submitting, but you can even do a deeper dive to show what those specific protections are for any given community.
That's helpful. And I think you actually just kind of segued perfectly into my next question. I was going to actually ask Ms. Coleman, as it was talked about, kind of the stakeholder aspect of using the EnviroScreen. I guess from the stakeholder position you have, what steps do you really go through based on that EnviroScreen in terms of outreach, or is it more so based on this, we're proposing these protections, or I'm just kind of curious how that works on your side.
Thanks, Commissioner Cross. It's a detailed planning process, and as Ms. Cook said, we use this as a tool. So we use EnviroScreen to try and figure out where we might be starting from and what those stressors might be. And then we really engage the community members to find out what their specific needs are and to ensure that the data also matches what we're hearing from our stakeholders. So for example, as she said, making sure we have interpreters on site, providing different types of accessibility measures. But as she also said, we use it through the process, the planning process, and Mr. Lytle can explain this, with our teams to ensure that our BMPs, the options that we have to include, hit on those EnviroScreen factors and that are also relevant to the community members.
And Mr. Lytle, those would be BMPs beyond what's discussed at the CDPHE consultation, or are some of them kind of overlapping?
I think it could be, thank you, Commissioner Cross. I think it could be a combination of both, right? I mean, I think that, we have very robust consultations currently with CDPHE and others. But I do think that there are situations out there where additional sort of data points and historical knowledge can inform even more on top of that. And that's where we would go and sort of, codify what those BMPs are in our permit application.
Thank you. And I guess one clarification, I know there's also been talk about the EnviroScreen 2.0 coming. I assume you would use the updated EnviroScreen for these kind of activities moving forward once that's available?
Of course.
Thanks, Commissioner Cross. Yeah, yes, that's true. I mean, by you all incorporating sort of a reference to EnviroScreen in your regulations, we would use the updated versions as they come out.
Okay, perfect. That's helpful. And thank you for this discussion. There hasn't been as much, this is kind of a new topic compared to some of the other things we talked about. So I just wanted to make sure that I understood the use of that. And then I think my last question, building off the impact area a little bit again, I know Ms. Jost, you talked about kind of having the identified default, and then using that expertise early on to see if that default needs to change. And I guess I want to ask a couple clarifying questions with that based on some of what we heard as well from CPW and from CDPHE. And one of the things I'm most curious about is the working pad surface as compared to, as CPW talked about, you know, maybe it's more appropriate to have a buffer on the roads as well. And so do you have thoughts on that aspect of the impact area of, you know, maybe keeping to a mile or keeping to the mile with the buffers, but it being based off of that disturbance as opposed to just the working pad surface?
Yeah, and Commissioner, thank you for that question. Mr. Lytle, I might turn to you first to kind of talk about the working pad surface versus kind of the oil and gas location as a whole, especially as it relates to the pipelines and roads, the CPW conversation we had. And then I'll kind of wrap it up with just a general statement on kind of impact area, I think, because it's probably worthy of a follow-up to what Andy's going to say. So, Mr. Lytle, why don't you go ahead?
Yeah, thanks, Ms. Jost, and thanks, Commissioner Cross. It's a really good question. So I think, you know, when you think about sort of the working pad surface in relation to the oil and gas location or the disturbance area, the delta between those two can vary, and in some cases they can vary, you know, greatly. You can have a situation where a very close offset distance between the disturbance area and the working pad surface could be 10 feet. You could have a farther offset that could be 300 feet, depending on, you know, if you had detention, retention, you know, topsoil stockpiles, et cetera. In general, you know, the average for oxy locations is probably a range between 40 and 150 feet. So it's important to remember, right? Like, you know, the working pad surface, I think, works well because it really sort of defines where the operations are going to be, where the equipment's, you know, ultimately going to be. Whereas the disturbance area may be sort of more representative to, like I said, topsoil stockpiles, you know, stormwater features, et cetera. So there can be a range when thinking about sort of the disturbance area in relation to the working pad surface. But if I sort of take that to the impact area conversation, I think, and as I mentioned last week, you know, no two locations are alike. I mean, some have like characteristics, but as we've seen in the DJ, some are very different and dynamic. So having sort of a 1 mile baseline allows for, I think, what is a consistent approach. And then depending on the scale of the project or unique characteristics of a given area, additional considerations could certainly be analyzed. But just for an example, you know, roads, when we think about roads, we defer to the relevant local governments pertaining to how those roads and our ultimate haul routes are planned to be used. You know, we feel like this is a local government matter. And while our road use is generally a very minimal percentage when compared to other traffic potentially in the area, we work with them on things like road maintenance agreements, traffic studies, access permits, et cetera, to really determine what our proportional impacts to the roads might be when you compare that to the existing uses in traffic. So, for example, Weld County Code requires that we take our haul route from our oil and gas location to the nearest county collector road or arterial roadway or nearest highway for purposes of evaluation of potential impacts. We then provide that haul route information at the time of the relevant local government, in this case, Weld County's pre-application meeting, to solicit feedback from both the relevant local government, the proximate local governments, and we would take any other agency's feedback that might be in attendance at that pre-application meeting, because we value that feedback so they can inform our future planning for a given development plan. So I'll stop there, but knowing that, and for examples like that, we certainly recognize that certain resources might need additional conversation, but we don't believe the impact area should be expanded beyond what's currently proposed in the draft rules.
Okay, and I think before Ms. Jost, you build on that, I just want to make sure that I understand. And we heard about this from KOGA and API yesterday as well, that, you know, the working pad surface is different than the oil and gas location because of, as you said, sometimes it's the soil that's set to the side, et cetera, the topsoil. And so completely understand on that. But with respect to the roads, it's more so maybe not the automatic default, in your opinion, should be set to the roads, because that's something that's going to be talked about anyway with the relevant local government and with others at the pre-application consultation.
That's correct, Commissioner Cross, and it's at that pre-application meeting where we can really take that feedback and then inform whether or not, you know, what we have planned is appropriate, or we might need to think about something else. But that's accurate.
Okay.
Yeah, and Commissioner Cross, if I could just kind of like add maybe one more thing to this, and it's really just an expansion of what Mr. Lytle was saying. This is why the attendees at the pre-application meeting are very important. So when I look at the draft rule list of attendees, or, Oxy's red line that we submitted, we would have the ECMC staff, the director, relevant local government, proximate local government, potentially the BLM, Forest Service, Colorado State Land Board, Bureau of Indian Affairs, if there's a tribe involved, CDPHE, CPW, and the community liaison. So at that pre-application meeting, any discussions on a larger impact area than a mile can occur for water, pipelines, roads, wildlife, DIC, CIC, whatever they may be. But those discussions are occurring on the site-specific, kind of project-specific basis. And that is a type of collaboration that's really never been mandated in the rules. It's been preferred and it's been done by Oxy, but it's never been mandated in the rules by the commission to occur. And that collaboration should be allowed to grow, meaning like use that collaboration at the pre-application meeting to really determine what the impact area might be for those various resources based on that site-specific basis. So that's why Oxy really does want to maintain that 1 mile default area, because we think that to adopt a different threshold for different resources right now is unnecessary, because not only are they not supported by scientific or technical data, but it really wouldn't give those stakeholders the ability to collaborate and allow that operator to take back what that impact area might be in practice. And so that's why Oxy continues to push for the 1 mile to stay in the rule.
Okay, thank you for that. I think those are my only questions.
Further questions for the panel? Commissioner Oath?
Thanks. Sorry, I thought of a couple more. We heard from a number of parties about the importance for the NOx stuff to also keep in mind situations or operators who are not drilling and who are producing only, but are having non-compliance issues. I don't think that your proposal takes that into account, but wanted to see if I'm missing that or if you have thoughts on that.
Yeah, thanks for that question, Commissioner Oath. We did not account for that in our proposal because we believe that for those operators, they should be worked through the existing enforcement mechanisms at CDPHE. And Ms. Jost, please jump in if you'd like to add anything.
No, nothing to add there, Ms. Salgado. Commissioner Oath, we did not take that into account because we just did not agree with that portion of those parties' proposals.
Okay.
Commissioner Oath, I will say, I mean, that is a concern, and we do think it's an important part of meeting the NOx intensity is for operators that are not drilling or completing wells, that they continue to contribute and reduce their emissions, but the targets at CDPHE should cover that and the enforcement there.
Yeah, so, okay. I will not argue, but I appreciate understanding your perspective. Thanks.
Further questions for the panel? All right, really good dialogue back and forth. Really appreciate Oxy closing us down with the rebuttal testimony, case closing, etc. We will allow Oxy to move on. Commissioners, it is noon. We have one other, or basically two other topics. One is to hear from Green Latinos. I think we wanted to call them back on issues relevant to community liaison and no net adverse impact. And then I think we wanted to spend some time with ourselves, hopefully doing some foundational issue identification and potentially doing some assignments out before we break. And then we'll come back next week for 4 days of deliberations. I'm comfortable moving on. I could also take a quick lunch break and then come back for those last two issues. Does anybody have a preference? Yeah, John or Commissioner Messner.
I'm agnostic as far as the lunch break goes, but I do want to throw one other thing in there, is that I would like to request an executive session to discuss some legal issues that have been brought up over the rebuttal testimonies. And so how that fits in, it doesn't matter to me.
Do you want to have that session before we start talking about foundational issues?
I think so. I
Okay.
think so, yeah, because it may inform that for me.
Yeah,
So,
no
yeah.
problem. Well, let's do this. Let's take, why don't we take an hour and come back live at 1? Why don't we move to enter executive session now, and then during the hour break, we'll take 15, 20 minutes with an executive session with AAG Davenport. Does that work for everybody? AAG Davenport, could you visualize? Help us appropriately get into executive session, which we'll do during the break.
Sure. So we're moving into executive session now. We state on the record the purpose of that executive session with it, if the commissioners are comfortable with it, I think would be as authorized by Colorado Open Meetings Law to discuss legal issues presented in the course of the cumulative impacts and enhanced system and practices rulemaking. That's broad. That encompasses, I think, any question the commissioner may want to ask in regard to a legal issue raised in the proceedings. Does that work for commissioners' purposes?
I think that's fine.
Okay.
So
I'd suggest a motion along those lines. And I think it suffices to say so moved. And with a second and approval, we'll go into executive session.
all right, so moved.
Second.
Motion and a second to enter into executive session as articulated by AAG Davenport. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. All right, folks. So what we're going to do is, and appreciate the 79 people listening in, we're going to break from this Zoom session. We're going to return at 1 o'clock or thereabouts. And during the break, the commissioners will undertake an executive session in a different Zoom link with the AAG for the purposes set forth by the AAG just now. We will take make no decisions. We'll receive legal advice and we'll return at 1 o'clock here. So stand by. We look forward to getting back to you and to our afternoon session at 1 o'clock. Commissioners, I would suggest let's reconvene an executive session at, say, 12:35. Does that work? Okay. See you soon.
Mr. Chair, may I go to the executive session script?
Yes, please.
Thanks. Commissioners, we're returning from executive session. Before we went into executive session, I stated the purpose of the session was to receive legal advice and analysis as raised in the cumulative impacts and enhanced systems and practices rulemaking. We held that executive session. In the course of that executive session, no deliberations were had, no votes were taken, and no decisions were made. Mr. Chair, we need a motion to exit that executive session now.
So moved.
Second.
Motion and a second. All those in favor signify by saying aye. Aye. Any opposed? Motion carries. All right, we are back in open session at the Energy and Carbon Management Commission on Friday, September 20th at 1:40. Commissioners, I believe at this point, we had reserved a right to have Green Latinos come back. I believe we had potential questions around community liaison and perhaps some other matters. I see that we've got Ms. Cooley and others that are on the panel if they'd like to video themselves. Good afternoon. This is kind of unusual, so I don't really know the protocol because we've not done this before. I didn't know if you had more information you wanted to share to us before we jump into questions to you. If so, I'll ask that in the form of a question, and then it's on my time, not yours.
Thank you, Chair Robbins. Good afternoon, Commissioners. Jessica Zausmer with Earth Justice. Also here with Robin Cooley, Mike Freeman, also from Earth Justice, as well as Patricia Garcia Nelson from Green Latinos. And today we have 3 areas, Chair, that we can report back on conversations that we have had. We see those as our conversations with industry on our proximity approach for procedural protections and informational provisions in DICs. Also, our conversations with Attorney General Davenport and the concerns raised about legal authority for our no net negative impact standard, and then also our red lines to the community liaison role. So we do have some slides and are happy to walk through those if it works for you all, or if you have another approach, happy to do that as well.
That's fine. Go ahead.
Okay, let me share my screen. Can you all see that, the PowerPoint presentation? Okay.
Yeah, we can.
Great. Apologies, just getting organized on my end. Okay. We did want to take a moment, commissioners, to respond to some information that you have heard about Green Latino's proximity approach. You've heard from industry, including KOGA and OXY, that there have been discussions on our proximity approach for procedural protections in DICs. That is true. We contacted KOGA and OXY to have those discussions. Unfortunately, no agreement was reached. KOGA proposed on behalf of operators in this rulemaking a radius of 1/2 mile, which is about 2,640 feet, with the inclusion of CICs. We do not agree that this is, as KOGA has said, a substantial concession by industry. The default radius in the August draft rules is already 2,000 feet from sensitive receptors within DICs, and KOGA proposed an increase of only 640 feet. If you include end zones, 640 feet is less than 2 football fields. That was not acceptable as a compromise proposal to Green Latinos. Green Latinos strongly believes that given the 1 mile impact area and evidence and testimony that you've heard, even from ECMC staff, that impacts extend much further than 2,000 feet, particularly cumulative impacts, 1 mile is the appropriate radius for procedural protections in the rules. However, in an effort to move the ball forward on this issue, Green Latinos provided a counter proposal of 4,000 feet, which is about 3/4 mile, and the exclusion of CICs. We thought that was a reasonable middle ground between KOGA's proposal of 1/2 mile and our proposal of 1 mile. If you do the math, that is a concession of 1,280 feet by Green Latinos compared to 640 feet by industry. We wanted to provide that clarification, but Green Latinos still feels very strongly that this commission should adopt the 1 mile radius to ensure that DIC residents who are within the area where by definition potential impacts can be felt will receive notice and be reasonably engaged in the permitting process. We appreciate the opportunity to respond on this issue, and now I will pass to Robin to discuss our proposed cross-impact standard.
Thanks, Jess. So I guess we're starting with the bad news first. I appreciate the opportunity to give a more full response on the legal authority, and we have had conversations with AG Davenport, and I think we're just at an impasse in terms of we just disagree with his legal interpretation in this case. As I understand it, the position is that the commission does not have the authority to regulate to a no net negative or adverse impact standard, even for communities that the commission determines are already overburdened by oil and gas and other stressors. And I think the argument is that the mitigation hierarchy that you first avoid and then minimize and mitigate somehow requires you to allow some level of net impact. But I think if that's the case for every project, then the argument is that you have to allow incremental impact after incremental impact with no limit. And if that is the case, then I don't think you can possibly undertake your legal obligation to address cumulative impacts and protect disproportionately impacted communities. So I think, as I said a couple days ago, at some point, this commission has to be able to say that this is the impact, that's the straw that breaks the camel's back, and no more impact is allowed. And that's the point of cumulative impacts analysis. And that's really what we're trying to get at with our standard. So I've shown this language before, but the General Assembly has told you that you have to address cumulative impacts of oil and gas development, and specifically cumulative impacts to DICs. That's why we're all here. And, you know, I think the other important part of this statutory language is that you need to both evaluate and address cumulative impacts. But the legislature hasn't told you how to address. So you have a lot of discretion in determining how to address impacts to best protect public health and the environment. I would also just point you to your general obligations under section 3460-106 2.5a. And that states that the commission shall regulate oil and gas operations in a reasonable manner to protect and minimize impacts to public health, safety, and welfare, the environment, and wildlife resources, and shall protect against adverse environmental impacts. So the obligation is both to protect and to minimize impacts. We do agree with AG Davenport that section 3460-106 20.5, which comes from Senate Bill 229, also does incorporate the mitigation hierarchy into the commission's regulation of oil and gas development, specifically within DICs. But we disagree with the idea that the mitigation hierarchy means it can't require no net adverse impacts. We think that the no net impact standard really fits nicely into two different parts of the hierarchy. The first step in the hierarchy is to avoid adverse impacts. Avoid means no impacts. So you only get to step 2 if you can't avoid the impacts, and our proposal would avoid net negative impacts. But even if we get to step 2, no net adverse impacts also fits nicely into the mitigation part of the hierarchy. Nothing in the plain language of the statute suggests that you have to mitigate something to less than 0, or that you can't require compensatory mitigation resulting in no net adverse impacts. As you heard earlier today, the no net adverse impact standard is currently in Rule 502. And I think it's important to also look at Part 5 of the variance provision, which requires mitigation measures to avoid, minimize, and mitigate adverse impacts. So this language makes it clear that the commission saw compensatory mitigation to achieve no net adverse impacts, fitting squarely within the avoid, minimize, and mitigate hierarchy. And the commission made that clear in the SBAP language, where this is for the mission change rulemaking, talking about the Rule 502 variance. And it says that the commission intentionally used the terms avoid, minimize, or mitigate in Rule 502C5 because operators may propose, among other things, public projects or other forms of compensatory mitigation to offset any adverse impacts that would be allowed by the variance. So we think there's no support for the idea that the commission cannot require no net adverse impacts in DICs because of the mitigation hierarchy. In fact, the opposite is true. Green Latinos believes that a no net negative impact standard is entirely consistent with this commission's legal authority. And that's the standard that's appropriate for drilling in DICs, and certainly when operators are drilling within 2,000 feet of a home. So I think now we get to go to the good news, which is the community liaison red lines.
Thanks, Robin. We put together red lines on the community liaison role that had brought support from multiple parties, including, for example, Conservation Colorado, Earthworks, Western Colorado Alliance, Colorado Sierra Club, and 350 Colorado. We had the opportunity to meet with the Attorney General's office after our opening presentation to discuss our red lines and some concerns that they had with the language. In general, they wanted to ensure that the liaisons were not performing any duties that would be arguably legal in nature, given the non-legal nature of the role, and that our language was not duplicative of or in conflict with state employment law. So we've gone back and forth with the Attorney General's office on these red lines since that meeting in the hopes of addressing those concerns. And we met with the Attorney General's office again yesterday and can happily confirm that they have no concerns with the revised language that I'm about to share. No changes here. This is the original language from the rule governing the liaison's authority and qualifications. With respect to the duties, there were a few changes to our original proposal. The only change in number 1 was to specify that whomever is in the role will act as a liaison between the commission and DICs with respect to those matters that may impact DIC residents. It wasn't necessarily a concern, more of a clarification on the scope of the liaison's role here being specific to those matters that affect DIC residents. The only change to our proposal in number 2 responds to the concern that the community liaisons might have a conflict and be unavailable for all pre-application consultations. So we've proposed that they are invited to all pre-application consultations when a location is within a DIC. The changes suggested in Rule 224C2, allowing the community liaison to be invited to all pre-application consultations for locations within DICs, would also require a change to Rule 301G2G. And so we have proposed consistent red lines for that provision, which I will touch on in a minute. For number 3, we propose that the liaisons are able to review and provide non-legal comments on community outreach plans. Here, we propose the addition of number 6 to make it more clear that the liaisons have a role in the complaint process, connecting residents with information and resources regarding that process, and facilitating outreach regarding complaints to operators and the director. And here, number 10 would allow the liaison, to assist community members in understanding and accessing resources related to community benefits agreements and help residents organize a community benefits group as necessary. Green Latinos sees community benefits agreements as an important tool that can be used to help mitigate impacts in DICs. We understand that this commission cannot require CBAs, but a CBA voluntarily entered into would give community members a seat at the table to have real input into what they would like to see in order to support the project. And number 11 would allow the liaisons to provide a written summary of outreach to and the positions of DIC residents regarding the proposed oil and gas development, which would then be considered by the director in her recommendation on an OGDP. This would also require the addition of a provision to Rule 306A, which I'll discuss in just a moment. As a new subsection to emphasize the liaison's impartiality, we added subsection 224D. Understanding that the liaisons will be housed within the agency, we want to emphasize that they are an independent voice for communities. And finally, for the hiring provisions, 224E makes it clear that the ECMC will initiate recruitment for the liaisons before December 31st, 2024, and will provide monthly updates to the commission to make sure that this remains a high priority for the ECMC. This update will also be posted on the ECMC's website to give communities some real clarity as to when the liaisons will be put in place, particularly given the significance of this role. And before I wrap up, I do want to point out 2 accompanying changes in the 300 series that are related to our red lines. First, because we propose in Rule 224C2 that the liaisons will be invited to all pre-application consultations in a DIC, that would require a modification, as I mentioned, to Rule 301G2G, which currently invites liaisons to the pre-application consultations only if the working pad surface of the location is within 2,000 feet of a sensitive receptor in a DIC or within a CIC. So our proposed changes are reflected on this slide, and the Attorney General's office had no issues with this revision. And second, because we propose in Rule 224C11 that the liaisons will include a written summary of outreach and the positions of DIC residents as part of the director's recommendation, we added a provision to Rule 306A that would require the director to review and consider that summary before finalizing her recommendation. And again, the Attorney General's office had no concerns with this revision. So thank you for the opportunity, commissioners, to walk through these red lines, which we see as reasonable clarifications and additions that will help fortify the role of the liaisons as a meaningful resource and advocate for DICs, and really ensure that this role lives up to its promise for communities. So we're hopeful that with these changes, which we've worked on alongside the AG's office, that we can get the support of the commission. So thank you very much. And that concludes our presentation. So I could stop sharing my screen and see if there are any questions.
Just to start, you mentioned that you had shared this or with other groups. Can you remind me which groups have signed on to this?
Yes, absolutely. So further, we haven't been able to circulate the revised red lines to all of the groups that initially supported the original red lines, but we have heard back from parties that do support these revised red lines, and that is Conservation Colorado, Earthworks, Western Colorado Alliance, Colorado Sierra Club, and 350 Colorado.
Mm-hmm. Could you go back to, thank you for that. Could you go back to the duties part of your slides?
Sure.
So the one question I'm generally, and this is just off the cuff, in favor of these changes. I think they do a good job. Have you, the one concern I've got though is there's a lot of sort of prescriptive duties that are set forth in a rule, and we don't generally do that when we speak about things that an employee is going to do or not do. We normally leave that to the discretion of the director. Have you given, and so where I'm going with this is, if after we start using community liaisons and we realize they need to do something different, or a delegated authority is actually not the right way to go, I'd have to open up an entire whole rulemaking to make that change. Have you given any thought to having all of this stuff be like examples, and or maybe putting it in the statement and basis and purpose, which is not neat? So we wouldn't have to go back and have a rulemaking to, make the community liaison even better after they've done it for a bit. And this is all off the cuff, so it is a wonder on my part.
Yes, we see a lot of these, there are some duties that would be prescriptive, but we see a lot of this as really just clarifying the scope of the role, that the role of the liaison isn't limited to the application process or to the permitting process and new applications. So we think those types of clarifications are really helpful and wouldn't necessarily be prescriptive in nature about something that's mandatory that the community liaison has to do, but more just clarifications to the scope of the role. So we see that as sort of a distinction. We hadn't talked specifically about whether some of this language could be a better fit in the statement of basis and purpose. I think our goal, Chair, is just to ensure that this role is as robust as possible on paper. So I definitely understand those concerns though.
Yeah, and I'm not trying to undo that goal. I think it's a worthy goal. I just wanted, if we're going to do that goal, I want to do it in a manner that is going to be best available for potential tweaks down the road, because, everything evolves, right? I mean, we've never done this before. So to think that we're going to get it spot on right the first time is probably, incorrect, although we're doing a really good job, and in particular because you guys are helping us do this. So, well, I'm going to keep noodling on that notion. I might talk with my AAGs about it as well. Again, it's not to undo the good work. It's just to make sure that the good work is reflected in the right capacity and manner.
Can I just jump in there? I mean, what we have agreement for from all the parties is definitely regulatory language, not guidance or SBAP language. So just know that. And I would also just say that we see this as the minimum, not that it would somehow limit the community liaison from doing other things.
Okay, fair. Thanks, Robin. Others with questions for the panel? Commissioner Cross and then Commissioner Oath.
Thank you, Mr. Chair. And this is helpful. I was going to say, I actually had the same comment. I was going to say, would it make sense to have something like at the duties, say a community liaison's duties will include, and then kind of go through the list to see if that would be something that would be possible. But that was just one note on that. The other question that I wanted to clarification question I wanted to get with the red line here was on, and I can't remember, I didn't put down which number it is, but you talked about, I think it was the 301G2G, and changing that to just within a DI community. And so I was curious, given the kind of proposed proximity approach that you've taken, why it wouldn't have the similar proximity there. So if you could just provide some detail on that.
Yeah, thank you, Commissioner Cross. This actually was one of the provisions within our original red lines where we did not adopt a proximity approach for this reason. We see the community liaisons as, by statute, dedicated resources and advocates for disproportionately impacted communities as a whole, not those residents within 2,000 feet of a proposed location or working pad surface. And so we do think that it is appropriate to have this be more targeted more broadly at all DICs for this provision.
Okay. That is helpful. And then I'm just curious, and I appreciate what Mr. Tafoya also said yesterday as we spoke with respect to the CICs. And so one question I wanted to try and ask about some of the conversations you've had thus far, the negotiations about the proximities that have been addressed. Have you considered, or would you consider, a lower proximity if the CICs were excluded? Like if they were taken out of the rules?
Yeah, that's exactly what we proposed. We proposed 4,000 feet with no CICs.
But understood, but I'm saying if we could get industry side to say, we'll agree to no CICs since they keep pushing for these CICs as well, would that be something that would maybe budge to see if we could get closer between the half mile and the 4,000 feet? I'm just kind of curious on that.
I mean, we'd have to take it back to our clients, but I think that it did not feel like either side was budging.
Okay. Just thought I'd see if I could throw maybe potential chips out for the negotiating table. I think those are my only questions. Thank you again for this additional information. I appreciate the additional work on this.
Two things before I call on you, Commissioner Oath. First, Ms. Zalsmeyer, and how do you pronounce your last name?
Zausmer.
Zausmer. Mrs. Zausmer, do you mind sharing the slides to Hearings Manager Thomas so that he can get it out to all of our stakeholders? Because right now everybody can only see one slide.
Yes, absolutely. I will share the slide deck.
Okay, if you could do that kind of soon, that would be great. And then AAG Davenport, if you could visualize. You were noted on record that you didn't have concerns about the language. That's not an endorsement of the language. That's just a legal position that the language is legally okay. And I assume that ultimately whether to adopt language is a policy consideration. Could you kind of weigh in on that issue?
Yes, Chair, happy to. You've stated essentially accurately where I was. The AAG team that reviewed those red lines did not have legal concerns with the red lines. However, ultimately, of course, it's the commission's decision as to whether or not to adopt those red lines with or without changes. And your consideration includes policy concerns as well as legal concerns.
Okay, great. And I want to thank you and your team and Green Latinos for getting together and meeting and having these discussions. That's a really Colorado way of doing things. So I appreciate it. Commissioner Oath, you're recognized.
Thank you. First, I don't have any questions on the part of your presentation about the cross impact standard, but wanted to thank you again for kind of looking into that and taking some time to provide your response on the legal part, but mostly, but are also to just thank you for bringing forward that proposal and having us really think about, what is the consideration there in terms of, when we're evaluating the cumulative impact analysis, how do we ensure that it, is evaluating and addressing to like what standards. So really appreciate you that for making us like think hard on that. And then on the community liaison piece, I think just two quick clarifications. On the component that had to do with the liaison preparing a summary of conversations with community members. I think the first time you talked about it, Ms. Osmer, you said would allow the liaison to do this. And then later it looked like maybe it was written as a compulsory element. Was it intended to be a requirement or an opportunity for the liaison to provide that summary?
In our original red lines, Commissioner Oath, there was the liaison would have been permitted to provide a formal recommendation at the hearing on an OGDP of whether to approve with conditions, or deny that OGDP. But there were concerns about that being a legal, that would be arguably legal in nature at an adjudicatory hearing. And so we had changed it to be a formal recommendation that would be required for locations in DICs and would be considered by the director in her recommendation of whether to move forward with the application.
Okay, thanks for that clarification. And then the language itself for the summary, it was, that the liaison will sort of summarize or include the positions of the community members. And maybe that's fine. I just had a sort of a reaction to the word positions, which does kind of sound legal and adverse, sort of like adversary or, and so was curious if you would have, strong concerns with softening that to like, conveying feedback that the liaison heard or concerns that were heard or sort of just a summary of the conversation or something like that. Because I think that's what you're getting at without it getting to the adversarial part of it.
Yeah, I don't think that our intention there was to have that language be adversarial. So, I think we would be open on ways to modify that. I think we had considered language around, any known views of disproportionately impacted community members, things like that, instead of positions. So if that sounds more appropriate to you all, then happy to go in that direction.
Okay, thanks for that.
Further questions for the panel? All right, seeing none, we thank you very much for the work and for being with us today. All right, commissioners, we are through the party presentations, both case in chief and rebuttal. We now enter into deliberations. AAG Davenport, do you want to visualize yourself? Do we need to do anything with the record at this point?
I think that's your decision. The record does need to be closed at some point, as in regard to our previous conversation regarding closing the record. In my view, closing the record at this stage would be a clear indication from the commission that it was done. receiving information and comments from parties. And so if that's your desire, then I would recommend closing the record.
Okay. There is one thing that I wanted to do. I talked offline with Sabrina Trask, who is our cumulative impacts person, but was previously the permitting manager. There's been a whole lot of talk in this about the ECMC's pre-app process and how it happens. And I thought it might be good, and thank you, Ms. Trask, for visualizing and being with us, to have you kind of walk through sort of the current process as is, because we're being asked to debate and deliberate on potential changes to the process. So if you don't mind, would you talk to us about that? And that'll help frame the discussion as we move into deliberations.
Yeah, happy to do so and appreciate the opportunity. I do have a couple of slides. If I could have those slides shown on the screen, please. Great, thank you. So our current rules do not have a formal pre-application consultation or pre-application meeting process, but staff has been engaged in these pre-application meetings with Weld County and Garfield County for a number of years now. We did adapt Weld County's pre-application process. They have a really robust process in their oil and gas energy department. So we have adopted informally over the last couple of years Weld County's process. I've got on the screen here, you can see on our website, on our homepage, if you go under permits and then permits help, and then at the bottom of that page, a little bit of information about how operators can voluntarily request a pre-application meeting with us. We've been using these for the last over 18 months, specifically for locations or OGDPs proposed where the relevant local government does not have a similar process. And this has been a voluntary program since we've implemented it informally. Next slide, please. So I wanted to just do a quick walkthrough sort of the process. If an operator wanted to request a pre-application consultation with ECMC staff, they would go through our website, link there, email, they would print out the form and email it to ECMC planning and permitting staff with a number of attachments and information. That information includes a general description of where the development is proposed, both the mineral development and the surface locations, how many wells, and some sort of three main points, how many residential building units, and that includes, again, high occupancy building units, school facilities and childcare centers, how many of those units within 2,000 feet of a proposed location. Excuse me. Also, the status disproportionately impacted community. Is the location in or outside a DIC? Is the location in or outside a high priority habitat? And then staff would schedule that consultation with the operator and would also invite the relevant local government, any proximate local governments, CPW if the location is proposed in high priority habitat, CDPHE if the location is proposed either in a DI community or within 2,000 feet of any RBU. We might invite the state land board if the location is on state land board lands or is developing state land board minerals. And we would also invite the BLM if it's on federal lands or developing federal minerals, other entities such as the EPA as necessary. Next slide, please. So once everybody is together, these usually take place over Zoom or Google. It's a virtual platform. The operator generally will give a short slide presentation, not too different from a presentation they might give to the commission at an OGDP hearing. This is where they introduce their locations, their access roads, where they're going to have haul routes beyond access roads. So this might be places where, particularly in Weld County, where they're using county roads, any utility or pipeline corridors that are planned or will be used, the mineral area, timing of operations. At that point, we basically pull up the maps. I think everybody knows that ECMC has a really robust GIS mapping platform. We pull up those maps and we start to turn on different GIS layers. So we'll put sort of a point of reference, a long, X marks the spot where the proposed location is going to be, and then start reviewing information that is found on the different GIS layers. Some of those layers that we look at include high priority habitats, disproportionately impacted communities, floodplains, wetlands, other surface water bodies, as well as subsurface water restriction uses, water wells, public water systems. Of course, we look at existing and permitted yet undrilled oil and gas development. We talk about the ozone non-attainment area and any local zoning. We don't have zoning information in our GIS platform, but we do. Many different jurisdictions have local zoning information on their individual websites, so we often go and look at those as well. As we are walking through these different visualizations on the GIS maps with different layers, we're talking about some of the permitting processes that need to be reviewed throughout this process. So ALAs, again, taking a close look at residential building units, talking about surface owner preferences. That's where, if an operator has a surface use agreement already in place, sometimes the surface owner might have preferences on why the location should be sited here on their property versus here on their property. Engage CPW with their concerns, any concerns about timing restrictions, timing limitations, initial thoughts from CDPHE about any BMPs they would like to see added to the application, pipeline takeaway, electrification, exemptions, exceptions, variances. The topics are very wide ranging. Next slide, please. I have a couple of, finally I get to use graphics and slides. I do have a couple of examples of that I took from existing sort of previously approved OGDPs where ECMC staff had notes from a pre-application consultation. So this is, these are screenshots from a pre-application consultation with an operator and Weld County. These are actually from Weld County's GIS system, not ours, but we have similar capabilities. So in the first, the left-hand graphic, you see the blue box, that's the area of mineral development. The green circle at the top of that is their proposed location. I believe that the multicolored dots are houses and buildings and existing oil and gas and other features. But this is the initial proposal. What we commonly do then is turn on a buffer around every home or every building unit. So that second graphic shows some sort of pink circles. That's a 500-foot buffer to an RBU. In the third picture over, we've now added a very pale green buffer around the pink buffer. That's 1,000 feet. And then it's really hard to see in this picture, but there's actually a 2,000-foot buffer in very, very pale yellow. It almost looks sort of white. What you can see in that third picture then is where the pale yellow, the 2,000-foot buffers are displayed. Those buffer edges are outlined in sort of an irregular light blue shape. In that fourth diagram then, there's 3 orange dots that have been added. Those are potential alternative locations. What we're looking at here is overlays of, for every home, there's a 2,000-foot buffer. Wherever there's a hole in those buffers, so the light blue sort of irregular shapes, those are where there's no home within 2,000 feet. And so those are where we would ask the operator to focus reviewing or analyzing those potential alternative locations in their ALA. Next slide, please. This is another example of an OGDP that was approved, I think, a couple of years ago. The first picture shows the proposed development. There's a location outside the mineral area. It's that red rectangle is the proposed location. The red dotted larger rectangle is the mineral area. The polygons in green, those are the city of Brighton, just for scale. In figure 2, we've added the floodplain layer of GIS and the wetlands layer. Those are the blue areas and sort of the hatch marked areas that shows floodplains and wetlands. In figure 3, we've turned off the floodplain and wetlands, but we've turned on high priority habitat layers. And so we're looking at both 1202C and 1202D high priority habitats there that cross through the mineral development area, but the location, that red box, is not within HPH. And then that fourth picture there is where we've turned on the aerial imagery. You can still see the floodplain, the wetlands rather, in sort of that bluish color. And you can see I know it's small, I apologize for the size of it, but the proposed well bores then starting at that location that's identified in the small blue rectangle, and then those proposed well bores trending east to west across the development area. So this gives you a little bit of an example of some of the things we look at, particularly on the DJ, in the DJ Basin. The next slide has an example from the West Slope. The West Slope, we absolutely recognize the difference between permitting in the DJ and permitting on the West Slope. There's a lot of differences. The pre-application consultation really helps staff to start understanding the unique criteria or unique parameters that frequently occur on the West Slope. So in this first picture, you can see the yellow box, that's the proposed location. The first image, again, apologies, it's small, but it also indicates where the access road would be and where some haul routes are and some property ownership. The middle picture there with the purple circles, those are some alternative locations that were being considered in this OGDP application, which was previously approved. The third picture there, I wanted to highlight this one in particular. I believe it's a high priority habitat, likely specific to aquatics, since I think it looks like it's trending in a riparian area, and I don't remember which stream that is. But I wanted to highlight this diagram specifically because it shows the staff's capabilities to superimpose not just a circle over a location, but to also superimpose linear features. I know this has been a point of discussion in determining what the impact area could be. So from a practical or implementable perspective, it's very doable to have multiple kinds of shapes overlain on a map. And then the lower part of the diagram is just showing some of the complexities of timing stipulations for BLM permitting, for CPW concerns, and then for ECMC staff to understand sort of what is the timing limitations for all of those different agencies wrapped up into this one permit. Next slide, please. So what I want to try to describe here is that this pre-application consultation, it is very technical. We don't just sort of hypothetically talk about, well, if there was a proposed location here or there. We look at a lot of technical data. The operators come very prepared. They've done a lot of homework. They've brought a lot of information to us. We being all the participants, so local governments, CPW, CDPHE, ECMC staff, we ask the operator a lot of sometimes difficult questions like, well, did you think about this? Did you think about that? Show me what you're doing with this wetland. Show me what you're doing with this riverine system or this high priority habitat. We, again, all participants give the operator a lot of input to think about so that the operator is prepared to submit their application, when they do submit it, hopefully they've answered all of those questions by providing accurate and adequate information in their application upon initial submittal. The goal of these meetings, I'm sure there's more than I've identified here, but certainly reduces uncertainty for the applicants. We're telling them what we want to see in their application. It gives us a chance to talk about a local permit or a federal permit, any requirements that those permits must meet. How can we incorporate those into our ECMC permits? How can we reduce duplication across permits? How can we find some efficiencies between permits to reduce any disparities between the local process and ECMC's process? Similarly, it improves efficiencies between BLM and CPW with timing limitations for wildlife. And possibly most importantly, it provides a mechanism for continued relationship building between the operators, local governments, federal governments, CPW, CDPHE, and ECMC staff, really helping us develop good relationships with each other and our technical staffs with each other's technical staffs. Next slide. So what we've proposed in the August draft, everyone's seen it by now, Rule 301G, we propose that this pre-application consultation or meeting would be required for all OGDP and all CAP applications. It would include residential building unit owners and tenants within 2,000 feet of the working pad surface. Where those RBUs are within a disproportionately impacted community, this meeting would include the community liaison. We've proposed that the pre-app consultation would include by rule a discussion and consideration of cumulative impacts, what those impacts are, what the receptors are, what the sources of impacts are, sort of starting to have those initial conversations. And in doing so, gives staff, the director, staff on behalf of the director, the ability to make that impact area determination. I guess the two takeaways that I'd like to leave you with today is that these meetings give us the ability to collaboratively determine the impact area. It's not just staff, it's not just the director, it's everyone that is participating in these meetings, collectively trying to find consensus where possible. I will say historically, ECMC staff, I cannot think of a time when we left a pre-application consult and there was something still up in the air, that there wasn't consensus. If there was not consensus, then staff would definitely seek additional communication to try to find out why there's not consensus and what can we do to build that consensus. So the other takeaway today is that staff believes that the pre-app community meeting is a better forum for public participation. If we were to open up the pre-app consultation or technical meeting to the general public, it would potentially prohibit technical subject matter experts from having these in-depth technical conversations that we need to have at this early stage in the planning process. I think that's the last slide, and I'm happy to try to answer any questions you might have.
Thank you so much, Ms. Trask. That is a wealth of very pertinent information for the commission, and I really want to thank you for the time and effort. I think it is really illustrative of the work, the hard work, the diligent work that goes on behind the scenes that folks don't really get an understanding of. I mean, I'm the chair of the commission, and I don't know that I ever really fully understood the breadth and depth of the work that goes into all of this before the application is even filed. So I don't have any questions. I will look to my fellow commissioners to see if questions, but I do want to provide a hearty thanks from the commission.
It's my pleasure. Thank you.
Anyone else with questions? All right, we'll let you go. Thanks. All right, commissioners, we are at that time in which we have heard from the parties and we will move into deliberations. I've got a little bit of something that I wanted to run past us all to try to help with the process. I would like to suggest a process for deliberations for my fellow commissioners to consider. My suggestion is similar to deliberative processes the commission followed in past matters. I have three main goals in suggesting this process. First, to make deliberations as efficient as possible. Second, to allow commissioners to focus on issues that are within their respective areas of expertise. And third, to spread out the burden of being first to present thoughts on issues. With that, I suggest the commission first identify issues that we believe are fundamental to this rulemaking. We obviously have our issue list that we've posted, and it has kind of all the issues. But what I'm suggesting is we kind of refine it down to those that are kind of fundamental to the rulemaking. Then we would assign to commissioners one or more issues, and that commissioner would be the first commissioner to present their thoughts on their fundamental issue during the deliberations. Of course, each commissioner will still carefully consider each issue and are under no obligation to agree to or defer to the commissioner assigned to an issue. So basically, my thought is we can probably identify the top 10, 15 fundamental issues. Once we've done that, we can get them assigned out to each of us so that we spread out that. My thought is we'll break for the afternoon and we'll have the weekend, and then we'll start deliberations Monday morning. And again, I would anticipate at that point that the fundamental issues will just go in turn and allow each commissioner to sort of provide their thoughts, again, non-binding to anyone. And then we can see if we can reach consensus on some of the more fundamental issues, and then we can start targeting some of the other issues that remain on the list. So those are my thoughts. Would, like to hear what people are thinking about that. As you might have expected, I'm a kind of person, so I've already got a fundamental issues list developed, and I'm happy to share so that we could then, and I've developed it with AG Davenport. And so I'm happy to share. But first off, does anybody have concerns about proceeding in this fashion? All right, seeing none. Let me see if I can share a screen. All right, this is weird. Can you see my screen? Okay, so this is in no particular order. These are the issues that I have identified, or Kyle and I have identified as being somewhat fundamental. The setbacks, the Rule 604 B and C issue, the cumulatively impacted community as an issue, DI, the definition, public comment notice, community liaison, local government involvement, both the pre-app, the consider and defer, Rule 315 and NOx, impact area and how to determine in the process, biological resources and CI for wildlife, definition, evaluation, swap, no net adverse impact issue, no net adverse, yeah, I said that right. Rule 316 ESPs and Form 2D, industrial facility definition, and then ALA and Rule 304 cap and cider is kind of a broad issue. Because I'm sharing a screen, I can't see you. So if anyone disagrees with these as fundamental issues, we can discuss and take them off the list. Or if anybody has other issues they'd like to add to the list, I'm happy to add to it.
So I don't know if can you see me, Mr. Chair?
I can, but you're the only person I can see because you're talking.
All right. Well, is it okay if I jump in?
Absolutely.
Just a couple of quick thoughts. So NOx, I think, is also part of Rule 316. So it says 315 NOx, but and then
Oh, should that be 316? Did I get that wrong?
so there's the part of 316 that is NOx, and then the part that's intensity targets and the Form 2D and stuff, and then there's the part that's ESPs. So so now this and the one below, a few below, are a little bit duplicative. So
All right, hold on just a second. I don't know what I did, but now I've lost my screen share. Oh, there it is. Okay, so what else should I make a change here, Commissioner Oath?
well, I think it's fine. You may actually just be able to delete that bullet because the 1, 2, 3, 4 bullets below, you say rule
Right here.
SP and Form 2D. And so I think that's
So
generally
delete and
Okay.
then add in.
Yeah, down here, I think it's, it's ESP, it's Form 2D, and then it's just kind of Knox. Yeah, exactly, Knox.
Something like that. Yeah.
Okay.
Okay.
And then I think there are, in Rule 315, the cumulative impacts, I think you've got a number of things throughout here, including like impact area. I think there are probably some other big things in here, like, whether to set threshold standards. Not sure if I know exactly what else, but give me a moment. And then Commissioner Messner, it seemed like he had some other thoughts as well. But that would be one I think we need to.
So do you want me to type up threshold standards or
Yeah.
type up? Okay.
Yeah.
Okay.
So I also have a list. Mine is not typed. Mine's long though, and I think some of the things I have in here, and I based my list on the list that AAG Davenport developed and gave out to the parties, plus additional information on there from party presentations in the rebuttal stages. But I wonder if I could go through this and someone could tell me whether they feel like it's captured in these bullets or not, because they may be captured. I'm not sure. And some of them I know are captured. And so there was some testimony, and I think would be worth discussing the definition of reasonably foreseeable future development. And I don't know if that's captured in here.
I don't think it is, Commissioner Messner. So do you want me to add to the list so that we've got one that we can all look at, or what are you thinking?
That's what I'm suggesting. Yeah. So if it's already captured, that's fine. If it's not, maybe we can include it.
Is that in, sorry, is that in 316 Knox ESPs and Form 2D? Excuse me.
Yeah. Let's all just pretend like we can all pipe in because I can't see you anyway.
So I've got it down as a definition issue, but I think it is also in what you're talking about as well. So they're interrelated, right?
Yeah. I mean, maybe definitions is one, right?
Just like definitions in general.
Yeah. Because there's a couple things I think that people have brought up with just definition, either requiring definitions or clarity in definitions in general.
Yep.
Okay, I'll just put it like this and I can add to the definitions if we think about specifics. Go ahead.
And then, well, I see conversation about CIC, conversation about DIC. But where would the conversation happen on this list around the proximity approach that's been considered, which kind of ties into both CIC, DIC. Again, it ties into a number of different things. And so I'm trying to like fit it, but I think just the general term proximity approach may be worth discussing.
I was gonna say, I think it's under the disproportionately impacted here as it talks about public comment and notice.
So you'd agree with that insertion, Mike?
I think so, yeah.
Okay. And if anybody disagrees, just pop up. Actually, and once everybody talks, I can see you. You don't go away. It's weird.
So I've got down rule 302. And of course, my notes are shorthand, so I'm not even looking at the rules now, but around local government, the local government citing piece. And I thought that you had that in there.
Right here?
Consider versus defer. So yeah, it's in there. It's in there.
Okay.
That one's in there. That one's in there. Lesser impact areas.
Help me.
I don't see
AAGs, where would that go?
That's rule 304D. But
Mr. Chair.
Yeah, go ahead.
welcome correction. My recollection, I'm trying to get back to my notes on this. I have too many screens up, was the lesser impact area was encapsulated by, shoot, I'm sorry, maybe ALA discussions, and I don't know if that appears in maybe as part of the ALA discussion in Rule 304.
This one, right
Yeah.
here.
Yes.
So let me put it this way. Is that good? Everybody comfortable with that?
I'm good with that.
Okay.
I've got a topic here because there's like, and Oxy highlighted this in their testimony, but this list of kind of other 300 series rules that were not, big changes or suggestions, but things that, but are just kind of the other general ones. And I think that's also captured in that initial one, but I could just leave that one for now.
Okay. And again, this list in my mind is it's not exclusive. It's just to get us started on kind of the bigger ticket issues that AAG Davenport and I were trying to illuminate.
So the other big one that I think's big, kind of encapsulates both Rule 308, 311, 312. And that's, Form 2's permit expiration and subsequent operations. And I don't know if that's captured in here or not.
I don't think it is. Because the rule basically punted on that. And so the question for us is that the right policy call or not? So let's put it on as a big issue.
Okay. And then yeah, I think those are all captured. Those are all captured. Those are captured. So these are things within things, but when we're talking about cumulative impacts analysis, there was a lot of discussion about what should be included in the cumulative impacts analysis. And so maybe it just becomes part of that, but there was some thoughts or discussions from some groups around, like Brett said, thresholds, reclamation, water quantity, and a number of other considerations around so I guess the topic is what should be included in a cumulative impacts analysis, and maybe that's captured.
What do folks think? Do we want to I'm happy to make an adjustment.
I mean, my 2 cents would be, I guess I'm trying to figure out between like fundamental issues and just like there are a lot of sort of sub issues or additional things we'll want to work through. Maybe that falls into the latter category, at least for me, but
that's fine. I mean,
yeah,
I'm not agreeing one way or the other. So
yeah.
We're going to stumble our way through all of this.
So I think the big things are hit on my list. I just wanted to kind of try to compare my list with what you had to make sure that.
No, I thoroughly appreciate and predicted you have a good list.
Yep.
Mike, Brett, did you have any additions, deletions, thoughts?
I don't think so, Mr. Chair. The pre-app consultation issues, I assume we would be wrapping into the proximity approach. Does that sound reasonable? And then, I mean, certainly there was significant talk about community agreements and our potential role. My only thoughts are just I like the way that you've approached it largely through, topical identification, and it might be even good to, I don't know if it's helpful to have the specific rules in, or if it's too constraining to have the specific rules in some of these. I like the topical approach and the assumption that whoever is approaching that issue first will, by nature, approach everything that falls underneath that argument as well.
Mm-hmm. Commissioner Cross, anything to add?
I was going to say, I think one thing that in sort of the breakout, we have 308, 311, 312, and kind of the expiration discussions. I think one thing that was under, I think it was 308, that doesn't necessarily fit in that group, is there was also some reclamation discussion. So I don't know if that's a sub issue or if that maybe goes with some of the potential wildlife and environmental type issues.
Yeah,
So
I put 308 in there from a timing perspective, but you're right. I mean, there's more to 308 than that. And so
I just don't know if we want to call that one of the foundational issues and put it in as something else, but some of the reclamation type issues were also addressed.
I feel like that's something we're going to end up talking about kind of as a sub thing, similar to Commissioner Oath on the other matter. So all right, well, if we're through identifying our list, AAG Davenport
Chair
and I,
Robbins, can I
Yeah,
just
go
make a
ahead.
suggestion? Because I feel like
Absolutely.
you have duplicative, you have a bullet that says industrial facility definition and then definitions. So you might just want to, can probably eliminate the industrial facility definition bullet. So shorten the list.
Excellent idea. Like it. All right. If this is our at least initial take on a list, AEG Davenport and I talked about it during the break, and this is the proposed breakout that we were going to suggest to commissioners. I tried to rely on commissioners' hats and their areas of expertise. And then we would need to bring in some of the new things into this list as well. Anybody want to do any horse trading? Are people comfortable with their initial set forth of things to run lead on? And I can email this to everybody as well. AAG Davenport, can you help me a little bit here and walk us through the additions we just made so that I can then type it into the relevant commissioner?
I will do my best. Happy
Here.
to. I think we need to add the last 3 bullet points above
So-
your assignments.
Okay, so threshold
the-
standards. Where do folks feel like that would land the best? Or who wants it?
Well, the threshold piece is a cumulative impacts piece. And so there's a couple of different places it can be. I mean, it can be in the wildlife stuff with Brett. It could be in the
Yeah, and if that's the case, I don't mean to interrupt you, Commissioner Messner, but I do think that, thresholds might be media specific. And so, if we've got me looking at wildlife stuff, I think the thresholds would be probably specific to that. If we're talking about air thresholds, it might be more appropriate. Sorry, Commissioner Oath, to volunteer you there.
No worries. I was gonna say the same thing. It kind of goes with just 315 in general, which does include impact area. So I'm fine to add that on.
How's that? Air, wildlife, and other.
Good by me.
All right. I'm comfortable taking definitions unless somebody else wants it.
Well, that sounds great, Jeff, but I would just caveat, I know that biological resource is one of the definitions, and so if there's a larger subcategory, I presume that you would,
How about that? But not BR.
there you go, thank you.
Well, there's the definition of disproportionately impacted communities as well.
Yeah.
And that one's,
How about that?
so I'm taking disproportionately impacted communities, right?
Yep.
Okay.
Does that include CIC or where does that go?
Yeah, Mr. Chair, you may have deleted CIC when you added definitions to.
Oh, I had CIC because I've got some ideas around this that is going to address CIC. But Commissioner Messner, you can address CIC too. You know.
Well, don't worry, I'll address them all. But
Oh, I'm not worried about that at all. And then the permit expiration, subsequent operation.
I'm
I'm
happy
happy to take that.
I was going to say, you identified it. Do you want it?
Sure.
I might kick myself for this, but Commissioner Ackerman, one of the things in your list is no net adverse impact. Is that something you would like to take the lead on? And if not, I'm happy to take it instead.
I mean, I'm happy to seed that. If you have ideas on it, you're more than welcome. Again, like Commissioner Messner said, I fully believe we'll all address these significantly, but I have no objection to you leading that one if you want to.
Is that our first horse trade?
Kind of more of a horse giveaway.
Horse give? Yeah, I didn't see any trading.
And then I guess, Mr. Chair, you noted that cider other than biological resources issues, I wonder if maybe anyone would be averse to adding that to my list, the cider biological resources issues. So not taking away from that, but adding the biological resources portion of that to my list. And wildlife, if you wouldn't mind.
For all the 80 people that are watching, this is the sausage making. Anything else?
Mr. Chair, would you mind scrolling up just for a second? I can't see the very top of your list.
There you go.
Thank you. I think we've captured everything in the initial bullet point list down in the assignments.
Okay, great. I will email this to you, AG Davenport, and then if you could get it out to the rest of the commissioners. I don't know if we need to file it in the filings or not. I'll leave that to you and hearings manager Thomas to figure out. Then AG Davenport, if we're done here, should we make a determination about closing the record at this point?
I think that would be appropriate. If I may, I have a question on your suggestion that about whether or not this should go to the public. I think I'd like to ask the commissioners if you want it to be made public, and that's sort of related to closing the record, because if this assignment list is made public and you're interested in hearing from the parties, they'll have an idea of who to contact on things, but it also is related to your question of whether or not to close the record, which, as I said previously, should, I hope, be taken by the public and the parties if you do close the record as an indication that you are not interested in hearing from parties.
And I think the last time you spoke about this, you also indicated the caveat that, a party can still, text or call a commissioner. It's up to the commissioner whether they want to take that text or call. Is that accurate?
That's accurate, and you would have to reopen the record then if you took information from parties and used it in your considerations. I think really, and I know I've said this at least 3 times now, closing the record is an indication that your preference is not to receive those attempts to communicate.
I think I'd weigh in the option of leaving it open, frankly. I've enjoyed the dialogue with folks as we've gone about this 2.5 week long process. Commissioner Messner, you had raised your hand. So ahead, Commissioner Ackerman.
Yeah, I would agree. At least having it open through the weekend, I think, would be helpful. As there's been a lot of communication between parties, there continues to be refinement and negotiation of folks' ideas. That's always good to know, at least different parties' perspectives, if they've shifted over the weekend. I see a time when we would want to close the record before significant deliberations, Monday or Tuesday, but I don't know if that needs to happen before then.
Commissioner Ackerman?
Yeah, I think we're thinking the same thing. My suggestion would be to revisit it at the open of the meeting on Monday.
Okay. So commissioners, I believe we are at that place where we're ready to adjourn for the day and reconvene Monday, the 23rd at 9 a.m. Does anybody have anything further? Commissioner Oath?
Yeah, sorry. I'm just trying to think about work process from here. We've also gotten a lot of new red lines and information in the last 24 hours or 48 hours that I, for one, have not had time to read in great depth and do kind of side-by-side comparisons. So I want some time to do that, get my thoughts together on this. And then if we're potentially hearing from parties, having only 2 working hours for all of that feels a little daunting to me personally. So I don't know that I have a suggestion. If others feel like they're going to be ready by 9, I will also do the same, but I will put that out there as a question of, are folks comfortable with that, or would a bit of a buffer on Monday morning be helpful?
I'm fine suggesting we start at 1. It'll give us 4 or 5 more business hours as opposed to working on Saturday and Sunday. What are others' thoughts?
I appreciate that. I think I'd find that helpful as well. I mean, certainly a lot to continue to wade through. So,
okay. I'm seeing no one vigorously interjecting that they're dying to start at 9 a.m. Let's start at 1 o'clock on Monday, the 23rd. Commissioner Messner?
Just so you know, on Monday I do have a hard stop at 5:30. So just a FYI.
Okay, no, that's good to know. Otherwise, we're set for Monday, Tuesday, Wednesday, Thursday, I believe. Is that accurate? In other words, not next Friday. Okay. All right. I would note that we are adjourned until Monday, September 23rd at 1 p.m.
Mr.
Thanks,
Chair.
everybody. Yeah, go ahead.
Sorry, just one quick point for clarification. Since the commission chose not to close the record, then I'd recommend putting the assignment list out publicly so that folks know who's assigned to what issues. Is that acceptable to the commission?
Yeah, that's fine. And if one of the hearings officers or managers wants to make it look a little prettier too, as opposed to my scribbling, that would be great. So let's plan on doing that. So parties, all 66 of you that are still with us, that'll be in the filing. It'll be filed and you can have access to it. The record is not closed. Commissioners will be working this afternoon and Monday morning, is probably a bit over the weekend as well, on the issues. And we will see everybody Monday at 1 o'clock for the initiation of deliberations. Thank you all. It's been a lot of work, heavy effort, and good work on behalf of everybody. Have a good weekend.